Just for those in the room, I don't know if this is working. We're going to be starting a bit late because one of our members is stuck in traffic. There was a wreck on 96. So maybe 15, 20 minutes. We're not totally sure.
Oh. I call to order the meeting of the Michigan Board of State Canvassers at 10:26. A slight delay from our meeting, which was called at 10 o'clock because of a substantial delay on I-96. Director Brader, was the meeting properly noticed?
Yes, it was. I just want to note that we will be posting an updated agenda this morning or sometime in the next couple hours because under the special election calendar that was called by the governor on Wednesday, we have a filing deadline for candidates who are running in House District 13. They have to file with the Secretary of State by 4 p.m. Today. And the Board of State Canvassers has to approve the candidate listing with respect to that office, which has to happen this week. So the board's preference is to do that today, but we have to wait for the deadline to elapse. So I believe the board's plan is to get through the agenda items. Other than that, then take a recess and reconvene shortly after 4 o'clock to approve that.
Thank you. We have a number of people who have asked to speak in the public comment section. Several of these have indicated that they wish to speak on X My Tax, and we will take their comments when that item number 3 on our agenda is reached. We have also asking to speak in public comment, Reggie Davis. Can you press the button for your microphone and
Yep,
spell your name and name for the record?
that's Reggie Davis, REGGIE DAVIS. Reggie Davis. Good morning,
Good morning.
Madam Chair, to you and the honorable board members. On behalf of Detroit City Council Member Mary Waters, City Council Member at large, I want to thank you guys for your service and to speak to a critical issue that our residents in Detroit are dealing with in regards to property taxes. It's a major situation for us. For several years, Detroit residents were vastly overassessed on their property taxes and the value of that, leading to evictions and foreclosures and furthering the devastation that our neighborhoods endured during the Great Recession. Estimates place the overassessed amount at nearly $600 million. You guys are very familiar with that, I'm sure. And to this day, Detroiters have not been made whole. Our city government in Detroit is using property taxes to punish Black and brown residents while transferring our city's wealth to billionaire developers. Our tax dollars, far from staying within our community to fund needed public services, are being captured through predatory programs that strangle the funding for our local institutions. Detroiters need tax relief, Madam Chair. Detroiters need a fair shot. Detroiters need to be made whole for the theft that the city has perpetrated against them. Finally, Detroiters need a tax system that keeps their tax dollars in their community to build and rebuild the public services we require. Our current property tax system fails to do this. And the other proposals like the land value tax system would only further the destruction of our neighborhoods. These council member is very interested in alternative taxation systems and believes that this proposal helps facilitate a debate on ways to reform our tax system in Michigan to be more equitable. Detroit City Council Member at Large, Mary Waters, thanks you for your time. I again am Reggie Davis here representing the councilwoman, and she would also like for you guys to know that she and her team is in total support of Ms. Carla Wagner and the Axe My Tax Group.
Thank you.
Thank you.
Yeah, I thought that your comments were going to be directed to something else, and we will reserve the remainder of the Axe My Tax comments for a few minutes later. But thank you, Mr.
Thank you, Madam Chair.
The next item on the agenda, well, let us hear first from Mr. Gallant. Is it Gallant or Gallant? Gallant, okay. Mr. Gallant? Okay. So if we cannot connect with Mr. Gallant, let us take up the consideration of the meeting minutes for November 6, 2023. Minutes have been distributed. Do we have a motion?
I move that we accept the meeting minutes from the November 6, 2023 meeting.
All in favor?
Aye.
Aye. Motion carries. I should have noted that Member Bradshaw is unable to be with us today. We got Mr. Gallant.
He's having audio issues, so we did recommend that he email his comment and then we can provide it to the members.
Okay, so we did receive an email from Mr. Gallant, a very extensive email immediately prior to our last meeting. In that email, he again urged us to have Attorney General Dana Nessel address us and determine that we are bound by the Roberts Rules of Order. I personally have reviewed material sent by Mr. Gallant. I did not find anything that persuaded me that we needed to call Attorney General Nessel or ask for her to address the Roberts Rules of Order question, which he has raised with us on a number of occasions. So if he has, since he sent us about 250 pages of material, I don't know that he would be asking us for, suggesting anything in addition. So does anybody else have any idea or any comment? Do any of the other members have a comment about Mr. Gallant's request? All right. Then when we do have an audio connection with Mr. Gallant, we will just advise him that we are not going to take up the Roberts Rules of Order issue, which he has raised repeatedly with us. The next item on the agenda is consideration of the 100-word summary of the purpose of the constitutional amendment sponsored by Axe My Tax. The summary as drafted by the director is appended to the agenda. I was stuck for about an hour on I-96. And Mr. Brewer, who I know wants to address this item on the agenda, item number 3, called to say that he was also stuck on I-96. So I would propose that we put off discussion of item number 3 until Mr. Brewer arrives, if it's okay with fellow board members. I would like to take up item number 4, consideration of the form of the first referenda petition submitted by Referendums of Michigan, LLC. And I see one person who has indicated that he wants to speak to this item, and that is Dorian Tyus. Mr. Tyus, nice to see you again. I would note that the first referendum petition seeks a referendum on public 2023 Public Act 2.
Yes, Madam Chair. Good morning to this honorable board. On behalf of the Michigan Democratic Party, myself, Dorian Tyus, on behalf of the Michigan Democratic Party, we ask the Board of State Canvassers to reject the referendum petition filed on November 17, 2023 by petition sponsor Referendums of Michigan LLC. The sponsor's petition fails to comply with the requirements for an initiative petition under Michigan election law and the Michigan Constitution, and therefore must be rejected. The petition must also be rejected because the sponsor has unnecessarily delayed submitting the petition beyond a time frame that would make the petition feasible. First, the sponsor's petition must be rejected because it fails to comply with legal requirements. MCL 168.482 subsection 3 requires the sponsor to provide a summary of the purpose of the proposal. The summary must also describe the proposal's purpose. Here in this case, the sponsor has not described the purpose of a referendum on legislation. It is simply not proper language describing a referendum petition. The petition language starts, a referendum of legislation to suspend Public Act 2, pending a vote by the majority of electors in the state of Michigan at the next general election. This language is incorrect, confusing, and is not accomplishing a referendum as contemplated by Michigan election law and the Michigan Constitution. The language of the Constitution in Article 2, Section 9 is clear. The people reserve to themselves the power to propose laws and to enact and reject laws called the initiative, and the power to approve or reject laws enacted by the legislature called the referendum. No law as to which the power of referendum properly has been invoked shall be effective thereafter unless approved by a majority of the electors voting thereon at the next general election. Now, it is true that if a referendum is properly invoked, the law in question is suspended, but the referendum itself is on the question of whether a law enacted should be approved or rejected. In this case, the sponsor's summary as to the proposal's purpose and identification of this fails to comply with the statutory and constitutional requirements, which is an issue of form that requires the board to reject the petition. Furthermore, the summary fails to adequately identify the legislation involved in the referendum because it references a public act, Public Act 2, number without including the year of the public act or which public act it's referencing. Similarly, the instructions beneath the summary also fail to identify the year of the public act. This omission creates ambiguity for the voter being asked to sign the petition and raises another defect as to the form of the petition. Number two, the petition is also barred by laches because of the sponsor's unreasonable delay. Just as problematic as the sponsor's defects with the form of the petition, which this body is looking at, is the delay in the timing of the petition. The sponsor's petition must be rejected for failure to timely start the referendum process beyond a time frame that is reasonable or possible to succeed. As indicated in the Bureau of Elections document on the instructions for initiatives and referendums, the sponsor could have started the process for the date the legislation was enacted into law because a referendum petition is not subject to the 180-day limitation on signatures as other statewide petitions. The legislation that is subject of this petition, Public Act 2, 2023, was enacted in law on February 1st, 2023. The sponsor had over 8 months to file the petition. This petition is essentially barred by the doctrine of laches because of the unreasonable delay, which has now made the petition impossible to accomplish, will waste unnecessary resources of the Bureau and this board, and possibly cause confusion to voters who will be voting in the presidential primary at the same time as they are being asked to sign this petition. Now, under Section 9 of Article 2 of the Michigan Constitution and codified in law, referendum petitions, quote, must be filed with the Secretary of State not more than 90 days following the final adjournment of the legislative session at which the law that is the subject of the referendum was enacted. That's MCL 168.471. The law that is the subject of the referendum, in this case, moving Michigan's presidential primary to the fourth Tuesday in February, starting with February 27, 2024 primary, will continue to be effective until the referendum is properly invoked, which is when the board finishes its canvass and makes its official declaration of the sufficiency of the referendum petition. The board must, quote, complete the canvass of a referendum petition within 60 days after the petition is filed, and a, quote, 15-day extension may be granted by the Secretary of State to complete the canvass, according to MCL 168.477, subsection 2. The final adjournment of the legislature occurred on November 14th, 2023. 90 days following November 14th is February 12th, 2024. Beyond the filing date, the board has a potential of 75 days to canvass the petition before making its official declaration on the sufficiency of the petition. Importantly, while on February 27, 2024 is the date set for the in-person voting in the presidential primary, which will start long before February 27. Now, for example, the impact of this will be on January 13, 2024. Voting will begin when clerks submit ballots to military and overseas voters. On January 18, 2024, absentee ballots will be available for all eligible voters. And on January 28, 2024, early voting may begin in communities. All of these dates would precede the filing deadline set for this referendum petition. And because of the time frame established for canvassing the petition by the board, the presidential primary will occur and election results will be certified most likely before the canvass of the sponsor's petition will be complete. Now, the sponsor is to blame for this predicament by unnecessarily delaying the submission of this petition to the point where it is not feasible now. Instead, the sponsor waited until after sine die to file this petition. The sponsor unnecessarily waited months to start a process that has now run out of time to accomplish. Additionally, the sponsor is wasting board resources and risking confusion around an election that will be happening at the same time the petition is being circulated for signatures. And for these reasons, we believe this petition must be rejected.
Thank you. Questions for Mr. Torres?
I think so, but I don't know as I have them formulated yet. I'm almost somewhat curious if Director Brader or Mr. Fracassi might just give us a rundown of this process and what is required, how exactly the referenda processes would work. I've been on this board for 3 years now, or around 3 years, and I don't recall a referenda being before us in that time. And so it's it's obviously different from these other items we've taken up. So some kind of a little refresher would be helpful.
Sure. Yes, you're correct, Member Don. It's been quite some time, I think, but since the board has had a referendum petition. It's been at least since 2015, which is even dates before me on either side of the board. So in general, the process is relatively similar between an initiative petition and a referenda petition. The main difference is that a referenda petition has to be filed 90 days following final adjournment of the legislature. So in this instance, legislature, they did sine die on November 14th. The filing deadline to file signatures is February 12th of 2024 then. There is a similar approval as to form process. There's a similar summary language process that we have with other statewide initiatives. The sponsors have not requested summary. The board approved the summary language in this. It's the same with initiative. That's an optional process for the sponsors to elect. Same with approval as to form. Once you get the approval as to form, you go through that process and you begin circulating. You still have to file the copies with the Secretary of State's office. And then you can begin gathering signatures. And again, those signatures have to be submitted in this instance by February 12th of 2024. The board's process for reviewing the signatures is the exact same as it is for statewide initiatives, constitutional amendments. It's the same standards, random sampling is utilized, all of that procedure is the same. And then on the back end of it, if there are a sufficient number of signatures, it essentially freezes the law from going into effect. And then it goes to the next general election, the next November election of the even year. So in this case, it would likely be November of 2024. And the people would basically be presented with a question that says, do you want to, I don't remember the exact language, so I may be wrong on the exact language, but do you want to refer the law? And at that point, then it's a yes or no, essentially. Oh, yes. So right now in the process, we're at that very initial stage. So again, sponsors have not requested summary language be drafted by the director or approved by the board. We are at that approval list to form part, the approval list to form stage with the initiative petition with the referendum petition, again, which is also an optional part of the process.
Question, maybe, Heather, maybe you can answer this one. Well, maybe you can't. So just hypothetically, if this goes through and the signatures are gathered and those deadlines are met, and just say for sake of argument, enough signatures are presented and you bless it, we bless it. You really truly are practically at an impossible standpoint, right? You have an election a few days later that votes are already being collected for. If they're cast. Would this in effect invalidate then the practically would it invalidate the 27th?
A court would probably have to answer that question. But yeah, I mean, time-wise, you're correct. I mean, if the review were completed, then voting would have already begun for the presidential primary at that time.
Can you remind us how many signatures are needed?
At least 223,099 valid signatures.
Which would have to be collected within the 90-day period by February 12th.
It would have to be collected by February 12th. There's no similar with referendum like there is with initiatives. There's that 180-day. So it's not like with referendum, it's not like it's a rolling 90 days or anything like that, but it would have to be in this instance, based on when it is submitted, it would have to be between then and February 12th.
So if this went through and if it ends up in a situation where they did get enough signatures, and it obviously would end up in court about the validity of an election on the 27th. So right away, the new election season starts out with issues in front of the court dealing with the election, right? And is there anybody here from the petitioner,
Nobody has that.
the sponsor?
Nobody has filed any.
You're from the sponsor?
Yes.
Could you fill out a blue slip and maybe chat with us?
Sure. I have a question on the timing. You mentioned the issue that they waited too long, but then the statute references it needs to be within a certain time after sine die till they've adjourned. And am I misreading the situation that they didn't wait too long because they were playing muck around? They waited till this point because that's when the legislature adjourned.
So they could have filed before the legislature.
It wasn't a requirement to wait until.
That's correct. So there's no requirement that you start within a certain time, similar with initiative and constitutional amendments. There's not a starting point per se. The only thing with referenda is that filing deadline. They technically could have submitted this at any point between whenever the governor signed the law and the the 90th day following sine die. There's no, like, it has to be within certain time. All the statute says is that the filing deadline, the deadline to file signatures, that minimum of 223,000, that has to be done no later than 90 days following adjournment. There's no starting timeframe.
Thank you.
Mr. Tyus, let me ask you a question. If they did collect enough signatures and we validated those signatures within the statutory period that we had, and the February primary had already taken place, would this possibly affect future primary elections? And couldn't it still be effective as to those?
Yes, it could be, but I still go to my initial argument, which is I don't think it meets the form requirement as well. Even though we're talking about obviously the impact that it would have specifically with voters in 2024, because absentee ballots are going to be out and things of that nature, and it would have an effect to future elections. The language on the petition specifically says Public Act 2. And so if I'm a layman reading that particular language referring to Public Act 2, doesn't say Public Act 2 of 2023. It could be Public Act 2 of 2018, 2015, whatever the case may be. And so, you know, obviously as it relates to form, we don't think it meets that threshold. And to answer your question, yes, I think it would have that future impact.
I have well, why don't we, thank you, Mr. Tice. Why don't we hear from is it Mr. Urban? Yeah. Can you spell your name for the court reporter, please?
Yes, Madam Chair, it is Paul, Paul. Last name is Urban, U-R-B as in boy, E-N as in Nancy. Good morning.
Good morning.
How are you?
I'm fine.
Good.
What would you like to tell us?
Well, what would you like to know? Well, we submitted, so what, and you'll have to excuse me, Adam, again? Yes, what he was explaining is, yes, the approval to form process that we submitted the petitions for, following the guidelines submitted that the board approved. Basically, there are the same processes for a referendum petition to follow suit. It is a little different than a statutory or legislative initiative or a constitutional amendment. So we are submitting the petitions for the referendum for approval to form. We could have asked the director of elections to draft a 100-word summary for us, but it was not a requirement that we do that. So we chose to submit the petition as approval to form for your approval, so we can get them circulated and get them going.
Want to address the issue raised by Mr. Tyus with regard to the timing of the primary, which is scheduled to begin. The primary is, as I understand it, on February 27th, so that ballots would go out 45 days before that.
Well, this is one of the things why we also drafted this petition, because with proposal 2 coming through last year, it really shifted around a lot of different things. And because the board and a lot of residents in the state of Michigan are unfamiliar with a referendum petition, this already, as you can see, he did bring up very valid points. And this is one of the reasons why we are referenduming this law that was passed, because how can you? What you're asking and what he was stating, you're right. But if we get the signatures, yes, it would suspend the law until the citizens of Michigan vote on it in November of 2024. So we suspend the law until that point, and then essentially we vote it through. Then the primary goes back to what it originally was prior to the legislation being enacted by our representation. I believe we can get the signatures, and I do believe there are a lot of people that are very interested in not just learning about the process, but being a part of it as well.
You do understand that the board or the Bureau and the board together have 60 and upwards of 75 days to validate those signatures.
Yes, ma'am. Yep.
Does anyone have questions for Mr. Urban?
I'm just trying to think through the timing on all of this, and if they hadn't waited, for instance,
Sure.
we'd still have the issue of confusion on this actual primary and what the results do. I mean, I'm a little slow today, so I apologize, but because of the compacted time frame on this, if you had started the process when the law was signed,
Mhm.
we get this at that point, then the signatures are out there. We could still be in the same bind with having no answer on the referenda prior to this primary taking place. Is that, am I correct in that, or am I wrong?
I think it would just depend on the timeline. I mean, theoretically, if we had gotten this early in the year, we could have completed a review process. The board could have determined whether there were valid signatures, and then based on the process that Adam outlined, it could have been settled prior to anything being done to effectuate that presidential primary. So printing ballots, et cetera. I think Adam's outlined what would happen now if we review signatures in time. Is there would be that question. There are future election dates as well. So there's a lot of speculation there. I can't really say exactly what would have happened in an alternate scenario.
So without wait, if it had been before us quicker, you could theoretically have had a situation where, okay, we know that they've got the signature, so it's suspended in February. We're going to go with what's currently on the books for March, and then the people vote on it. Would the vote have occurred at the March primary, or would have been the next November? Okay.
The other thing I'll just add, just to clarify in terms of where we are in the process. I mean, so, as noted, they didn't have to request a summary, and they didn't. They also don't have to do what we're doing right now. This is a courtesy that BOE staff and the board provide to folks to look at the petitions before they go out, to make sure that they comply with the form requirements, so that when they come in with the file petitions, we're not seeing for the first time a form issue that would reject the entire petition after they had spent all the time and money collecting those signatures. So this is an optional process that the board provides as a courtesy. What they do have to do is, before they actually start circulating, they do have to provide a copy that applies, right? They have to provide a copy of the referendum that's being circulated.
I have a more fundamental question than just the question regarding timing, and that is the language. It says a referendum of legislation to suspend Public Act 2 pending a vote by the majority of the electors at the next general election. I don't think that that's the language for a referendum. The referendum is the power to approve or reject laws enacted by the legislature. So what the question is, what the summary should say, I think, and I have worked on several referenda, it should be a referendum on 2023 Public Act 2, asking the voters to approve or reject that statute at the next general election. And this is very confusing. This a referendum of legislation to suspend Public Act 2 pending a vote. It doesn't say that what is being sought is a vote either to approve or reject. So that's one thing. A second thing is that it just says, as Mr. Tyus argued, it only says Public Act 2. It doesn't say 2023 Public Act 2, and it doesn't have the citation. So I know that our, excuse me, our publication on sponsoring a statewide referendum petition says that it should include the Public Act number and the MCLA citation. I don't know if that needs to be in the summary on the top of the of the petition, or if the complete Public Act number and MCLA number can be on the back of the petition. I believe it should be on the front of the petition. So I would like you to address those issues if you would.
Sure. Do you have any thoughts on that? Let me just first correct what I just said, though, which is actually under 483A, which I just cited. They do not need to give us a copy if it's a referendum. That's only for initiated law or constitutional amendment. But Adam, do you have thoughts on the rest of?
So with regard to the specific citation piece, I don't think the law is clear as to that. It is the full citation is on the back. Whether or not it needs to be in the summary or not is I don't think that is clear in the law. And I will say that that's also not something that we looked for, because they're not requesting approval as to the summary. We don't, when you don't request approval as a summary, we just look to see if something is there. And then if something is there, that's sufficient for our purposes when we're looking as to approval as to form.
Madam Chair, I have two questions for staff or legal. We're going to keep putting you guys on the spot as much as we can here. Is it unique in your memory that there would be a referenda on statute that deals with election dates? It is I've been around for 20 some years, and it's unique in my memory. Now,
I can't remember that occurring. I mean, the only thing that would somewhat be related was, there were some in 2020, some of the governor's emergency declarations. They didn't change dates, but they did affect certain election procedures, and that general power the governor had under the Emergency Powers Act was challenged. I can't recall any. I'm not sure the last time election date was changed, but I can't recall any recently.
But go ahead if you had a thought.
So the last time an election date was changed was the May consolidation, and I don't remember when that occurred. But that's been a while. That was the early 2000s, right? And with the exception of the most recent statute changing the presidential primary, we had the last referendum that I'm actually aware of actually did deal with elections. It dealt with, I believe it dealt with straight ticket voting and repealing straight ticket voting. I'm looking at Mary Ellen because that was her case. If I'm remembering correctly, I think that was both the last referenda that we've had as well as an elections one.
And I guess the purpose of that was related to kind of a follow-up on if there was any court decision or interpretation of this issue related to time, but also related to the lack of stating the year of the Public Act, if any guidance from the courts exists on that.
No, I'm not aware of anything that would be similarly, on point to not having the year included in the summary.
My recollection certainly is that we had the full Public Act title on the referenda for straight ticket voting, and also for an earlier referendum on
that could be
related.
The point is there's not a case that says it has to be in there.
I'm sorry.
There's not a case that I'm aware of that says it has to be in the summary.
Because I can argue with myself on this. Of it to me, it is important. I think in what we do here, as much I like straight factual identifying information that you can provide is what we're looking for. But on the flip side, based on the fact that there are certain timelines that are required for this, in practice could really only be talking about Public Act 2 of 2023. Steve's shaking his head, so and Steve, you know what you're talking about, so I understand. I'm not gonna put, I mean, you can,
Could be circulating still in 2024. There could be a Public Act 2 in 2024. The legislature convenes the second Wednesday in January every year under the Constitution. So in theory, that could be the Public Act 2 being enacted at the same time.
This is the introvert speaking. I don't have any audio. Thank you.
Steve, would you mind coming up to the microphone? The folks on Zoom couldn't hear. Thank you.
Any help you can offer is
Right.
appreciated.
Steve Lito from Dyken. I don't have a client here, just responding to Representative Daunt when
oh, I'm not a representative.
I'm sorry. Member Daunt, in theory, there could be a Public Act 2 of 2024 prior to the deadline for submitting these. Under the Constitution, the legislature convenes the second Wednesday in January. And so the legislature would be in session and could enact a new law. I'd also note that with a Public Act number that low, I don't believe you would have, going back to the formation of the state, a regular or special session where you wouldn't have had at least 2 Public Acts. So there's probably a Public Act 2. Sometimes there are multiple Public Acts in a given year, in those years when you have a session. So it may not be at all clear which Public Act you're referring to. And I can just state, having looked at a number of referendum over, probably a couple of decades, not aware of any public referendum that didn't reference both the act number and the year.
Thank you.
And Mr. Urban, let me address this one to you. I still have a problem with your timing, okay? I don't have a problem with what you want to do going forward after 2024. But I have a problem with the timing, and I have a problem with us exercising just a bit of common sense.
Sure.
You're in effect trying to put something in motion here. That is, to me, strikes me like we're playing Russian roulette with the election system. If you get your signatures and you bring it in, and the board has to come back and certify it, and now you have folks overseas in the military who have filled out ballots in good faith, and you have people who are voting in advance and they're filling out ballots absentee in good faith, and you're coming along and saying, well, no, we have to invalidate that election because we have enough signatures to hold it off. You just see the problem with that story.
Yeah, I see the logistics of it. Yes.
Let me ask you you're not going to answer this question, but I'm going to ask you point blank anyway.
Mhm.
Was that your intention in filing this at the last minute like this?
No, honestly, it was not. It was not. So
Never
we just,
considered that.
no, and we filed it because, we have been learning this process for about the last 6 months of really diving into the Michigan Constitution and trying to learn how we can referendum initiate legislation. And I will say, the Bureau of Elections, the staff has done a fantastic job of helping us put together this petition. They've done a great job. They've answered all my questions. Never in the time of our discussion through internet did they ever say, and I would not expect them to, your time frame, because we have always understood, reading Article 2, Section 9, that is 90 days that we have after the final adjournment. Now, I do understand if the argument is that, they enacted the law back in February, why are we waiting till now to do this? I understand your concern with that. And to be honest, it's because we've been learning this process on actually how to initiate a referendum, what steps we need to go through to do this so we can be successful in a referendum petition drive.
So hypothetically, based on what you just said, if this petition were not blessed, your next step then would be to come back to us again with a revised petition for future elections. Is that how you're answering that question?
It depends on what we choose to referendum. I mean, the legislature may not pass another set of election laws in 2024. If they do, and it's something that, you know, our group feels that we should draft a referendum for, then we will, and we will present it to the board for approval. And at that time, though, instead of, I guess, the time crunch of now, yes. But again, you know, this has been a process for us to learn too, that we've gone through. And I'm glad that we're going through this. I'm glad that you guys are all having this discussion as well. I think it's important that, you know, obviously a referendum hasn't been tried in the state for a long time. But it's also the citizens' ability to hold our legislative body accountable, you know, for laws that we don't approve of. So this is why we're doing this.
If I may, a kind of basic question for me too, you know, when you referenda something, you don't like it for some reason.
Mhm.
What is kind of what is your underlying problem with this change in law and moving the primary up?
Well, from what I'm from St. Clair County. So when this law was passed, there was a lot of discussion within your, you know, county GOPs on how this was going to affect the delegates going to the national convention and so on and so forth. So because we were going through this process and learning it, we discussed, hey, let's get a referendum petition together, go through the process, learn it, and submit it. And this is where we are. So a lot of the delegates in the state of Michigan that are part of the GOP are, you know, upset that that came through back in February or March, whenever the governor signed it. But this is now why we're here. So.
Thank you.
Yep.
It makes perfect sense to me, obviously.
You know, Mr. Urban, I appreciate the fact, I am impressed by the fact that you have undertaken to inform yourself about the Michigan Constitution and the right of referendum. But you have asked for approval as to form, but not for the summary.
Mhm.
And I think the summary simply does not comply, does not accurately set forth what a referendum is. A referendum is putting legislation before the voters and asking them either to approve or reject it. So all you have here is a referendum, excuse me, to suspend pending a vote. And it's not saying pending a vote either to approve or reject. So that is a major problem for me. In addition, I believe that the guidance says that there should be the full Public Act number and the MCLA citation. And that should be, in my opinion, on the front of the petition, not on the back. So it would be, and I understand, and I think you understand, that we don't necessarily have to approve your form. But I would not be able to approve the form because I think it is not proper.
Yeah, I appreciate Mr. Urban's time and intent on putting this forward. I do think, you know, there's no secret, I'm a Republican member of this board and have a long history of Republican activism. My personal opinion is this rush to move the presidential primary up in this fashion and adjourning early, and all of these cartwheels that the governor and the Democrats are doing are cynical at best. However, for me, the lack of the Public Act 2 of 2023, I think is an issue. And if we had that, and then you've made some valid comments about, you know, the language of suspend, et cetera. Those type of fixes, I think, would put this in a different spot. But the lack of the 2023 with Mr. Lidl's advice settles the question for me.
Okay, thank you.
Yep.
What's that?
You know, I too, I think what you've done is great. It's,
you.
it's, you know, there's some questions about how it was done.
Sure. Again, we appreciate going through this process because for us, we're learning, right? So, you know, when we come back again, you will see more referendum petitions that will come. And it's good. And I'm really glad that you guys will get to look at them and we'll go through the process. So I appreciate your time and looking at them. Thank you.
Take a time to comment for us, too.
Absolutely. Thank
You'll
you.
Keep learning.
Yes.
And
Thank
so
you.
will we.
So do we need a motion then? Okay.
I would recommend yes, whatever the board lands on, but I would recommend having a formal motion, yes.
For the purpose of my motion, would it be best to include my reasoning that it's because it does not include the year of the public act?
Probably.
Okay.
Some sort of reasoning, yes.
Then I move that the board reject the form of the first referenda petition submitted by Referendums of Michigan LLC because the language lacks appropriate reference to the public act being referred by not having the year of the public act included.
I'll second.
All in favor?
Aye.
And I would simply add that my vote not to approve the form is also based on the fact that the language does not accurately put forth to the people being asked to sign the petition that they are being asked to either approve or reject the legislation. I expect we'll see you again, Mr. Urban. But don't go away because
Oh, yes, you will.
you
I
have,
appreciate your time. Thank you.
you also have another referenda.
Yes, yes,
Aye.
ma'am.
And I think that it has, oh, no, I thought I did. Oh, did I? Yeah, we voted. Okay, okay. So we have a second referendum to suspend Public Act 38 pending a vote. So the same language is used.
Yep.
It does not include the year of the Public Act, but it also does not accurately set forth that the referendum is being sought to ask voters to approve or reject the legislation.
I'm not being sarcastic. Was that a motion?
No.
Okay,
This is
okay.
a Summary of what he has put before us. Okay. Do we have a motion? Is there anything you would like to say, Mr. Urban, about this petition as opposed to the one that we just discussed?
Well, Public Act dealt with the extreme risk protection orders that came through Lansing. I myself being an avid hunter and part of Gun Club in St. Clair County, obviously there was a lot of uproar. And again, going through this process, learning in it with, going through the approval process, working with the, Bureau of Elections was great in putting this together. Obviously this is a long petition. There's a lot of language there. But yeah, it was just something that a lot in our county and our surrounding counties up and down the thumb did not agree with. So we discussed it and we put forth this petition to referendum the extreme risk protection orders. So that was the reasoning behind that.
Does Mr. Tyus, that's the last name, right? Does he wish to speak on this one as well, or no? Okay. Then, for me, the issue is obvious again, and I think this one, there's just, my personal opinion is there's more leeway in terms of time, a little bit of
Yes.
time to get this correct, because it doesn't deal with, time. There's more leeway within bounds of the law, to get
Yes.
this correct, because it's not dealing with the election and the problems that could create. But again, I would move that we reject the approval because it lacks the year of the public act being referred, as well as does not ask the voters to approve or reject the legislation.
Okay.
I didn't catch you quick enough there. Sorry about that.
Okay, all in favor?
Aye.
Aye. The motion carries. We have not approved as to form.
What you were asking me about.
All right. Thank you, Board. Appreciate your time.
I'm sure we'll see you again.
Yes, thank you.
Now, Mr. Brewer has arrived. We waited for you, Mark, because we certainly understood that you were on I-96 when item 3 was on our agenda. So we will now take up item 3. We have Mr. McCord speaking in favor. We have Carla Wagner speaking. I don't know which way, but Carla Wagner has asked to speak. We also have Steve Liedl and Mark Brewer. So what order do you think is best? Okay. Yep, Mr. McCord, do you want to speak first? And Mr. McCord, I understand that you were furnished last week with the position letters that were submitted by Mr. Liedl and Mr. Brewer in opposition. So if you would, I hope that you will address that.
Well, good morning.
Good morning.
Madam Chair, the board, Director Brader. Yes, we were provided with the objections by Mr. Liddell and Mr. Brewer. And we have reviewed those. I would say that the consideration in front of this board, the task this morning for this board is to consider the 100-word summary prepared by the director, not by my client. We submitted one, but the director drafted their own. So the summary in front of you is not our work product. We were not consulted on it. We didn't have any communication with Mr. Brader on it or with his legal counsel as to the scope of the summary. I would presume that the summary meets the requirements of section 483B 3 and 2, and 2. I assume that Mr. Brader, in exercising his statutory obligations and his professional judgment, along with his legal counsel, prepared the summary in accordance with that standard. So as for the summary that is in front of you for your consideration, it is not our work product, and it is not for us to defend. Now, that being said, speaking for myself, speaking for my client, we have no objection to the language that has been prepared. No. I did get, like I said, when we mentioned earlier that, yeah, I did receive the objections by Mr. Liddell and Mr. Brewer. The thrust of Mr. Liddell's objection was that we did not first submit a petition along with the summary. Statute does not require us to submit a petition for purposes of 483B. 483B is a separate statute from 483. It's not a subsection of 482 or 483. It's 482B, a separate standalone statute which specifies an optional procedure where a petition sponsor may provide basically our version of the summary, which we did, and obviously kind of imply, although it doesn't say it in the statute, doesn't say it even in your manual, that obviously you have to provide a copy of the proposal in order to assist the director, at least in that regard, in writing a summary, right? We did that. Further, we submitted it. It was accepted by the Bureau of Elections. And in fact, the director drafted a summary. So to the extent that, first off, it's not required as a prerequisite that a petition be filed. It's not in the statute. Not in the statute. All right. The statute is clear. There is reference to it, but it does not require us to pre-file a petition meeting the format requirements of 482. All we had to do was provide a summary. We did that, and the director acted on that. And that's all that's at issue. So the arguments by Mr. Liddell are essentially moot. They're overtaken by events because a summary has been prepared by the director for your consideration. Mr. Brewer then raises a number of arguments, the thrust of them being that we failed to list out or republish various provisions of the Michigan Constitution that, in his opinion, he believes were abrogated. They're not. These provisions were not abrogated. Also, again, the summary was prepared by the director, not us. So it is for the director to defend that. But as I mentioned, these provisions were not abrogated. The other thing I guess I would note about this abrogation argument, first off, whether it's been abrogated or not, in my opinion, or Mr. Brewer's opinion, obviously you can get two lawyers in a room and they can disagree, about what the color blue is. The final arbiter of that legal question is for the Michigan Supreme Court to address. And all of the cases that have addressed that question have always occurred either after a sponsor has submitted a petition with enough qualifying signatures. So the argument as to abrogation, whether something is or is not abrogated, again, our opinion is that none of those provisions have been abrogated, is premature. Next, his final argument relates to the effect of the proposal. He is correct that the standards for drafting a summary are similar, indeed identical, to the provisions affecting the drafting of the actual ballot question. But as Mr. Liddell instructed me last time I was here, that is a different process that comes at a different time. So again, the argument is premature. Not only is it premature, but even in the AG opinion that's cited by Mr. Brewer, the AG recognized that while the statutory requirements are similar, this board can, at a later date, in considering the language for the actual ballot proposal, the question, can either they can use the summary as prepared, or they can draft their own. They don't have to be identical. It's not required. So again, I would say submit that argument also is premature at best. Thank you.
It is true, is it not, that you have not yet prepared a petition?
We have prepared a petition form, and we have gone through the staff process to as to the form of that, the internal staff process. So the answer to that is, well, we have prepared a draft, and that draft has gone through staff, but we have not submitted that draft for approval as to form in front of this body.
And you haven't submitted a petition. You have submitted what
We
you
have
would
not, we
put
have not, we
on a
have,
petition if you were to draft a petition.
we have not filed a petition either with the Secretary of State or this organization. We've asked for that the summary be prepared in order for us to acquire basically the procedural protection that is granted under the statute when it's prepared by the director. Once we have that summary, we are required in the statute to include that on our petition. So to prepare a petition only to have to resubmit when we're requesting as to the writing of the 100-word summary, until we have the 100-word summary, we really don't have a full document yet to either submit either for your approval or for to the Secretary of State's office.
We're all relatively inexperienced. Member Daunt has been here for 3 years. I've been here for almost 2. Mr. Hoskamp for 1, right? We have looked at a number of petitions in order to prepare 100-word summaries or to review the 100-word summary, which is prepared by the director. It's my recollection that every time we looked at a 100-word summary, we looked at whether it summarized the petition that was before us. I'm just making.
But just because that might be how other people have chosen to submit it, the statute doesn't require it. The statute does not require submitting a petition form. We submitted the summary and the proposal as it would be reproduced on the back of a final petition form. So just because other people might choose to do it that way, it's not in your manual to do it that way. So your public guidance is not consistent with that. And it's not required either by your manual or by the statute.
Sort of the long form, which we have in front of us too, right? The actual wording of what you're proposing. You're submitting that to us as well with the idea that if we went forward with you, that's not subject to change. Is that correct?
That's not subject to change, no. That will the form is our proposal. And to the extent that the summary as prepared by the director is approved by this board, we are required to include that approved summary on our petition form. And as we also learned last time, we are also required to present the long form on the back on which the summary was prepared off of. So there won't be any changes.
Long form exists the way you're presenting it today.
Correct.
That's what would be presented to
Correct.
people signing. Summary was written by Director Brader.
Correct.
Which we can review. Mr. Brader, by not having the formal body of the petition, the sheet with the signatures on, by not having that here, are we I'm not sure I have the right words to ask the question, but are we being short-sighted here?
Well, I mean, when I draft the summary, I'm just looking at the proposed constitutional amendment. So I don't need to look at the front of the petition to draft that. It is true in the past they've come at the same time, but unless the board approves the exact summary as I drafted it, which would be perfectly fine with me, of course. Typically what will have to happen in those cases, they're going to have to go back and change the petition anyway to put that summary on there before they bring it back in. Now, the board has also done the conditional approval as to form, which Member Bradshaw in her absence, I'll say she does not agree with that process. So she doesn't vote for that when it occurs, but the board can simultaneously approve the summary and approve the form, either conditionally with the idea that the summary will change or with the summary on there if it is unchanged and presented at the same time. That's, typically the practice that's been followed, but I'll just say it didn't affect the drafting of the summary to not have the petition, which is really a separate process. Adam, do you want to just add anything to that?
So the only thing I will clarify just to make clear is that we've had both ways. We've had sponsors that have submitted the petition sheet exactly as it would be circulated with their proposed summary at top. We also have had sponsors begin largely in 2022 to submit just the backside of the petition. So then they could get the summary that the board approves and then place it on the front side. It's been presented both ways.
So historically, there's nothing unusual here. This has been done before with a summary and a backside language. That's not new turf, right?
That is correct.
We don't have the backside of a petition. We have what is represented to us as what the petition will say if they have a petition prepared.
I would say that this is still the same form that we've gotten it before.
We would still be within the right understanding here that if, for example, these folks went out and the actual petition had something different on the back of it, we are not abrogating our right to say, hey, follow, right?
I think that's correct. I think that's actually similar to the board's position in the most recent
Raise the wage.
Raise the Wage.
Right.
That was and I know that case is currently in litigation as well, but that was probably the most recent example of that I can give. The process still remains that you have summary language. The next step would be approval as to form if the sponsors elect to seek approval as to form. And then at a minimum, because this is a constitutional amendment, you do have to do the 483A filing as well, which provides an as circulated version with our office before anything is allowed to go out.
Okay.
Do we have any more questions for Mr. McCord?
My apologies if I've missed this, trying to think things through in my head. Once you have a summary, so you have a summary approved, is your intention to seek approval to form of the whole piece moving forward, or do you?
That is our intention.
That is your intention?
That is our intent.
Okay, thank you.
See you again.
It looks that way. Although we have to stop meeting this way for.
Thank you.
Thank you very much.
Mr. Levito?
Thank you, Madam Chair and members. Steve Lidl from Dykema, representing Citizens to Save Our Public Safety in Schools. Here today to raise the issue that was submitted in a memorandum to you last week on the statutory requirements, both of, governing one, and most importantly, whom the legislature has authorized to submit documents for the creation of a summary. In what circumstances may the director prepare a summary pursuant to authorization by the legislature? And what may this board act upon in what circumstances relation to a summary? And I think I will turn to the language in the statute itself, right? Who may submit a summary of a proposal included in a petition? Well, it's a person who circulates a petition. What's the mandatory element? A petition and a person. So we used the example last month of my daughter with her book report and having it summarized by Mr. Brader. Does the statute authorize my daughter to submit a book report to be summarized in 100 words or less? Which I know would be competently done, but no, it does not. Does the statute as enacted by the legislature permit my dog to submit a document? My dog would likely eat it before you got it, but no, it's a person who circulates a petition may. Mandatory element, person and petition. Dogs don't count, book reports don't count, petitions count. Could the legislature have said the sponsor of a proposed constitutional amendment or a proposed legislative initiative may submit materials for summary by by the director? Sure, they could have. But you as a board are charged with enforcing the law and the text as enacted by the legislature, and a mandatory element is petition. So that's the words used in the language itself. In that section that you are asked to take action upon today, there are 4 references to the word petition. But you have a petitionless petitioner that has submitted materials to you today. You don't have to take my word of the statute for it. Take your own words from the Bureau of Election in a summary of the process. Right? On page 2 of my memo, the sponsor may submit the summary of the purpose of the petition to the board. Again, you have no petition. Again, the summary must also inform signers of the subject matter of the petition, but need not be legally precise. Again, a reference clear to the world that you must have a petition. Multiple references to a petition summary, a petition in your manual, informing citizens of this optional process. Even though this law was only enacted at the end of 2018, we have some precedent interpreting this. The Attorney General has opined on the constitutionality of this section of law enacted in 2018. And what did the Attorney General say when reading the law enacted by the legislature? How did the Attorney General interpret the language enacted by the legislature? Well, it's pretty clear. Public Act 608 also added section 482B, which permits but does not require, quote, a petition sponsor, right? And then it proceeds to use the words petition or petition summary 2 more times in the opinion. So we have these mandatory elements, as to why. Multiple times in the Attorney General opinion, your own guidance, and the language of the statute, most importantly. Lastly, we have another deficiency in your submission, which would have been corrected had the sponsor submitted a petition. Your manual in the campaign finance indicates that any petition sheet submitted to you must include this identification statement mandated by the Campaign Finance Act, paid for with regulated funds by the groups submitted. You have a group with retained counsel that has submitted printed materials to you, which does not include the disclaimer required by the Michigan Campaign Finance Act. So if you have any doubt or hesitancy as to who you should give the benefit of the doubt to, I would ask you, don't provide a benefit of the doubt to a group that has failed to comply with a mandatory element of the Michigan Campaign Finance Act. You have printed materials before you, at least the ones that were placed on the website. I see no mandatory interpretive statement included in those materials. So to summarize, the legislature has been clear. Who may submit a summary? Someone with a petition. Who may process? What may you process? Well, you may process a summary when you have a petition. What may the board approve? A summary when you have a petition. The sponsors were put on notice of this requirement at your last meeting. I made the same point about their last submission. And for those reasons, I'd ask the board to not approve, not act upon this non-compliant submission submitted by a group known as Michigan or MI-Ax MI-Tax, Inc. Thank you.
In thinking through the basis of your argument is setting the summary language aside. We shouldn't be considering that summary language at this point because the supporters or proponents of this have not provided the petition as part of the process. Whereas, is that correct? Basic?
Yeah. My argument is that it's a mandatory element that a petition be submitted because the only person eligible under the statute to submit a summary for approval is a petition. And if you look at all the additional language in your own manual and the interpretation, you have to summarize, what's included on the petition. There's multiple references to a petition summary. And I would agree with the arguments that you will hear. I've seen his memorandum from Mr. Brewer. It's a mandatory requirement that you summarize all of the provisions of the Constitution that would be abrogated. Certainly, the materials submitted repeat the provisions that are affected by the proposal. But there are multiple provisions of the Michigan Constitution that would be abrogated that you would have to see in any petition. It's a mandatory element that are not there. I don't know how you can properly summarize the proposal without the full petition, including all those items that aren't abrogated. And then lastly, I would note the mandatory element of who's for this, right? The legislature contemplated that the group proposing and financing a proposal would include that mandatory element. If the legislature had just wanted a proposal sponsor to submit the content of a proposal to be summarized, they would have used those words. They did not. They said that a petition circulator, mandatory element, may submit. We have no petition.
And if I may, Mr. McCord, your position is that it is not mandatory to submit an actual petition. You are going through the process of getting the summary that you intend to put on the petition, which you will then submit to us.
That's correct. And we also heard from the director that they have considered and prepared summaries in the same manner as my client has submitted theirs. Now, I will make one additional point that Mr. Liddell brought up, and I would notice that Mr. Brewer's correspondence to this board does not include a disclosure as to who is paying for his fees. The regulated funds disclosure that Mr. Liddell has said that we failed. Liddell, excuse me. Sorry, Steve.
Sure.
Mr. Liddell has brought up again, that disclosure as to who's paying for with regulated funds, that's not on Mr. Brewer's correspondence to this board. And he's made a submission.
He hasn't submitted a petition
No, but he's also
or a proposal for a petition, more accurately.
correct. But again, the other thing too is we do have a statement of organization on file with the Board of Elections. And I don't have the number right in front of me, the file number, but we do have a statement of organization that was filed, I believe, around October 6th of this year.
Yeah, I'll note, I did check prior to coming down here this morning. There is no group with the name of either AXEMI Tax, Inc., period, registered as a ballot question committee, nor is there a ballot question committee using the name AXEMI Tax registered as a ballot question committee either.
The sponsor filed a 501c4 organization under Axe My Tax, spelled AXEMITAX Inc. It's an organization that exists on the corporation website. On October 6th, a ballot committee was formed. They chose the name Axe My Tax, dropping the E. I was not informed of this, so to the extent that the documents include an E, that was a Scrivener's error on my part.
So apparently we now have 3 groups involved in supporting this proposal.
No, we don't.
We have a group that was registered with the Bureau of Corporations and Securities earlier this year using the name AXEMITAX. That's one entity, one group. If that group expended any resources in support of this campaign, it was obligated to file as a ballot question committee. We also have the name AXEMITAX, Inc. That would be a separate entity under Michigan corporation law, under the Michigan Nonprofit Corporation Act. If you want to use an INC in your corporate name, you're obligated to file an amendment to your articles of incorporation to do so. If not, it's a separate entity, separate name. And now we have the submission of a third group with a different name, AXEMITAX. We seem to have an issue with compliance with the law and the text as enacted by the legislature. And I would encourage this board to hold this group or groups, apparently now 3, to the text of the legislation as enacted by the legislature. and not give them any benefit of the doubt today. Thank you.
Mr. McCord. Mr. Brewer?
Thank you, Madam Chair. My name is Mark Brewer with the law firm of Goodman Acker for Michiganders for the Commonwealth, which is a registered ballot question committee opposed to this proposal. I want to thank the board for its kindness in rearranging your agenda to accommodate the difficulty I had this morning. So I thank you very much for that. I'd like to build on the comments of Mr. Liedl. I join in his arguments. But there's a specific deficiency here, which is quite serious. And that is, and this is unique to Michigan constitutional amendments, that a petition is required to list all of the provisions of the Constitution which are altered or abrogated. You won't find that in a referendum petition. You don't find it in a statutory initiative petition. It's a unique requirement for constitutional amendments. It's repeated throughout the Bureau's own manual, and petitions have been barred from the ballot for failure to comply with that requirement, most recently in 2012. I use the word petition advisedly here, perhaps put quote marks around it. The documents that have been submitted to you are not a petition, as Mr. Liedl indicated. But even if they were, they would fail this requirement because while they claim to have listed all the altered, amended provisions of the Constitution, they listed none of the provisions which are abrogated by this revision. And we gave some examples in our letter. For example, because school districts in this state must levy a property tax millage in order to receive guaranteed state funding from the state, and this proposal would remove their ability to do that, the guarantee of minimum state funding for education for every school district in this state would disappear if this proposal were adopted. That entire provision is abrogated by this proposal, even though they do not amend the text of the Constitution to do so. That is a very significant change, and that is why the Constitution itself, as well as the statute, require a listing of these abrogated provisions. So that is a significant way in which the petition, quote unquote, is deficient. But there's additional problems going to the summary. It is impossible for the director to draft or for the board to consider or adopt a summary which misses and does not include all the abrogated sections. Those are things that have to be taken into account if you are to comply with the statute that says you must give an accurate summary of the proposal. It doesn't say an accurate summary of the text of the amendment. It says an accurate summary of the proposal. And this proposal includes all the provisions of the state constitution, which are either altered or abrogated. So you cannot proceed, you can't even draft a summary of this quote unquote petition until the sponsors tell you in a petition they are required to file what provisions have been abrogated so that you can take that into account in drafting an accurate summary. So this is a fundamental deficiency in this petition. I know Mr. McCord may dispute my characterization. I gave three, I think, very clear examples in the letter. There are many, many other provisions of the Constitution which would be abrogated by this incredibly far-reaching proposal to abolish property taxes in this state. There are references to property taxes throughout the state constitution. There are voting rights, which are contingent upon people paying property taxes. That provision of the Constitution would be abrogated, but you would not know that by reading this alleged petition, and you certainly can't draft an accurate summary until the petitioners tell you what provisions their proposal would abrogate. Now, it is true, as Mr. McCord indicated, at the back end, his petition could also be challenged for that deficiency. But here we are talking about whether you can even draft an accurate summary, and you cannot without a complete list of those abrogated provisions. There's a further deficiency with the proposed summary, and that is that this board has repeatedly, we gave numerous examples in our letter, disclosed the effects of a proposal. It's not enough just to summarize the words. And frankly, the summary is full of legalese that would confuse, I think, any voter. You need to disclose the effects. This proposal would cut billions of dollars from schools in this state. It would defund local government, which are dependent for over 90% of their revenue on property taxes. And it would cause a massive shift to allegedly try to compensate for those revenue cuts in terms of the sales tax, liquor taxes, and other things. None of that is disclosed in the summary. The voters and the people who will sign this petition are entitled to know the effects of this proposal. And this board has repeatedly ensured that signers of petitions and ultimately voters know those effects before they vote on it. The legal words on a piece of paper are meaningless unless the board drafts a summary which discloses the effects, the enormous revenue effects of this proposal. With that, I'd be glad to take any questions.
Not necessarily a well-formulated question, and from me, the alter and abrogation argument. What would you say the Supreme Court's decision in 2018 in Citizens Protecting, I think it's CPMC v. Secretary of State related to the Redistricting Commission?
Yes, sir.
How does that impact or your thinking on the alter and abrogation? Because that was a key segment of that.
Right. That would be one of the cases that drafters of a petition should consider. In our letter, we cited the Protect Our Jobs case from 2012, in which Justice Zara, I think, very accurately summarized what alter or abrogate means. But certainly there are other cases, and I've done this. I've drafted constitutional amendments, and we presented those petitions to this board. We listed all the abrogated provisions, at least in our judgment, subject to second guessing by the courts later on. That's what's absent here. So in your answer to your question, Mr. Daunt, that is a case that drafters should consider. But the leading case in our view is Protect Our Jobs from 2012, in which a petition after circulation, collection of signatures was barred from the ballot because they did not list, in that case, one abrogated provision that they should have listed. You don't need to get to that now, Mr. Daunt. At this point, you can't even draft an accurate summary unless these petitioners tell you, in their opinion at least, what provisions of the Constitution are abrogated by their proposal. Thank you very much.
Carla Wagner, is that to speak? Can you spell your name, please?
Yes, I can. It's Carla, Karla, Wagner, Wagner.
You swear to tell the truth, the whole truth, and nothing but the truth.
I do.
Thank you.
Or I will. First of all, I am not an attorney. I'm just a small business person, small business owner, property taxpayer. One of my jobs is a real estate agent. I want to thank you all for your time here. Ask My Tax. As a real estate agent, I have dealt with a lot of people in the state of Michigan that are losing their homes. And most of this is because of property tax. We have to find a different way for the cities, the townships, and the counties, and the state to receive revenue. It can't be based on the fact that It's property taxes and only people that are paying property taxes, because not every property owner pays tax. The state of Michigan is now a state where 30% of its residents are renters. Renters pay through their landlords, but it's the services that we pay for with our property taxes. It's the services that the people use that need to be paid for. My house, someone's farm, someone's business does not use the service. It's the people that live in the building or the people that work at the business or the farm. They are the ones that use the services. So it's charging property tax owners based on the value of their property is not a reflection of the services that are being used. You can have a small business owner that pays property taxes at his home, and then he pays property taxes again at his business. His business will never go to the library. His business will never be able to be taken to the zoo or the museum. And yet he is paying for those services in two different avenues, one through as a homeowner, one as a business owner. Property tax payers, we're becoming a smaller and smaller group of people. Our baby boomers are being forced to sell their homes because they're on a fixed income and they cannot afford property taxes. So they're forced to downsize, they're forced out of their homes. We have farmers that it's their business, but it's also their home. We lost 400 farms last year and over 100,000 farm acres. We have small businesses that have their homes, their properties attached to their business. They mortgage their home to start a new business. And now both of those are in jeopardy because of property taxes. We are being crushed by gas, groceries, utilities, everything else that is going on here in our state that is affecting property tax payers. They're to the point they can't do it anymore. We have so many people that are losing their homes, and we have young people that don't even dream of owning a home. It's not because they can't afford the mortgage, which is amortized over 30 years. It's because they can't afford the property tax, and they have no say on the property tax. You have an assessor that comes out and assesses. You have cities and townships and counties that assign millages that people do vote on. But as I've traveled through almost 60 of the 83 counties so far doing presentations to people that are between 40 and 80 years of age that have been paying property taxes for multiple years, they don't even understand how their property taxes work. They don't understand that they should go and vote on the millages. They just don't think they even have any kind of influence. They just pay because they know if they don't pay, they will lose their home, their farm, or their business. So they just pay the bill, but they can't do it anymore. We have to find another way. When you have as many people as we do that are becoming renters and that aren't paying for these property tax services, at some point, and we have young people that aren't buying houses, we have elderly people that are losing their homes or being forced to sell. We have people moving out of the state. We know this because Governor Whitmer just formed a committee to find out where everybody was going and why. It's because people can't afford property taxes here. We have businesses that our governor is paying businesses to come to Michigan, and then she forgives them property taxes. How does that help the communities? How does that help the communities that those businesses are coming to when they are not going to be charged to pay for those property services, or the services in the community? Somebody has to pay for them. So it's going to fall on the shoulders of the property tax owners and payers, and they can't afford it anymore. We not only see it in every county here in Michigan, we see it in the cities, we see it in the townships. You heard Mr. Reggie Davis speak earlier about Detroit. This is happening all over the state, but more importantly, it's happening all over the United States. If anywhere you look, you will see that states are fighting over property taxes. They're wondering, do we forgive property taxes to our seniors? Do we forgive it to our veterans? Do we forgive property taxes on this group or that group or whatever? But anytime that we do that, all we do is pile it heavier and thicker on the people that are left standing. What we are trying to do, and I understand that these attorneys are way more educated than what I am, but we have been looking at this for 2.5 to 3 years. We have studied this. We have talked to township supervisors. We have talked to county commissioners. There is a lot of people on board with getting rid of property taxes as the revenue to pay for these services. Number one, because we are becoming a state of so many renters, we need to spread the cost of these services out amongst many people instead of only a small group of people paying for all of the services. We are not trying to defund anyone. And as Mr. Brader would realize when he wrote that summary, we have made provisions in that summary to repay all of the local townships, the counties, the cities. It's just shuffling the money. These are taxes that we have already paid. We pay so many taxes to the state. All we're asking is for a redistribution of some of those taxes so that we can cover our local services. My township that I live in right now, they currently get more money from the state as in general revenue sharing of just the sales tax alone than what we spend. There's multiple other townships that are out there that are the same. We're looking to increase the amount that they're going to get through general revenue sharing through our proposal that will help make sure that those essential services like police and fire and road commission, those will be covered for. Those will be covered. We will also have other means of covering some of the other services, but it has to be something that is done by everyone in the community and not just the people that are paying the property tax, because we're going to find out real soon. There's going to be more and more and more foreclosures. We have foreclosures are at the highest they've ever been. We have credit card debt. It's the highest it's ever been. We're going to have bankruptcies, more than we can ever even imagine. That's all coming down the pike. And we know that it's going to be, people are going to have to ask between, do we pay the property tax bill or do we feed our kids? Do we pay our property tax bill? Do we feed our kids, or do we pay for the zoo or for the museum? Those are on our property taxes, right? People are losing their homes because of a book in the library. People are losing their homes over the monkey in the zoo, and that has to stop. We have to find a different way, and that is what we are doing. And just to clarify what one of the attorneys mentioned as well, we have a Axe My Tax, AXEMITAX. We started with that corporation. We filed everything properly. I have filed many things for small businesses for many years. We filed that properly as an exploratory campaign to find out if there was enough interest in this. We can do that. As soon as we knew that we were going to come in front of the board here with a summary request, and soon to do the petition. We have the petition language because Mr. Brader had to look at that in order to prepare the summary. We now have filed our ballot question committee. It's under the AXEMITAX. We dropped the E, and we did that because we know we have to keep separate the finances. Once we start with the petition, getting circulations and then donations on that, and we have to file the finance committee. We wanted to separate the names so there was no confusion as to where the donations were going and how that campaign finance paperwork had to be filed. So that is under AXEMITAX. I looked at it again myself just to make sure that everything was on there. We have already filed one financial statement under that already. So that is AXEMITAX. The other one is AXEMITAX. So there are two separate, and it's mainly for financial differentiations. So we are trusting that Mr. Brader, we decided to go this route. We wanted everything to be legal. We wanted to put everything out there and be as precise and concise as we could be. That's why we came here with our 100-word summary that we had prepared. Mr. Brader rewrote it, made it more clear, gave it more definition. He was looking at the petition when he did that. That is what I believe the board here is to do, is to make a decision on that 100-word summary and not argue the body of the petition itself.
Thanks for the explanation. So there's two organizations. One is an Inc. and one is kind of a 501(c)(3).
One is, I believe, a 501, and one is a 501(c)(3) and the other one is a 501(c)(4). It's just like a candidate. If they want to start going out and finding out how much interest there is behind people getting behind what he has to say or a platform, that's kind of like an exploratory campaign. And until they file and declare that they are going to actually run as a candidate, you can sometimes have, you form a different committee, because this is exploratory and this is now we're actually funding the petition and funding the petition drive, et cetera.
Both of those organizations are filed and on file and current with the state of Michigan.
Yes, that is correct.
They're both. And
Yes.
the people who are you a principal in both?
I am a principal.
The principal or one of
Yes, I
principal?
am the principal of both. Yeah. So again, we started the Axe My Tax, the AXE. We started that one as an exploratory, just to go out there and find out how many people are, how many people would get behind a petition like this. But from what we understand is that once we start putting material out that tries to sway someone's vote, which is what a petition would do, right? Would you vote to eliminate property tax? That is now a different entity. And the campaign financing is done differently. And so we ourselves wanted to make sure that we had clear definition. This is this is this. So the name is basically the same, so we don't confuse people that we're trying to get signatures and things from. It still sounds like Axe My Tax.
You currently raising funds in both organizations?
No.
Are you raising funds in either?
We will be soliciting funds. Yeah, we have raised funds in the first one, the AXE, and it has gone to pay for some literature. The other one, we have not raised any funds under the AX yet because we are waiting for our 100-word summary.
Has there been flow
To
of
be
money from the first
They're
one to
two
the second?
they're two separate
I get that.
entities, two separate bank accounts, two separate
Has there
everything.
been money from one going to the
No.
other at this point?
No, the only money that is in the one, the new one that's AXMI is the $5 that the bank required to open the account. Mhm.
I have a question.
Sure.
We received a position statement from Huron-Clinton Metro Parks saying that the summary prepared by Mr. Brader does not reveal that there will be no money going to school districts, community colleges, libraries, recreation authorities, or other governmental units. That is true, is it not? Those entities do not receive any
So
distribution of income or tax revenue.
currently, I'm not sure how familiar you are with the budget, here in Lansing. So the state of Michigan here in Lansing, I'm gonna call it the Lansing government, currently receives only 2.5 billion a year from property taxes. It goes right into the school aid fund. Okay, that's the 2.5 billion that is collected from the state education tax, 6 mills on everyone's property tax. That is collected from our property taxes. It goes to the state education fund. It's only 2.5 billion a year out of a $24 billion school aid budget fund. So all of the other taxes that we pay, corporate business tax, sales tax, state income tax, alcohol, marijuana, tobacco tax, motor vehicle tax, real estate transfer tax, all of those go to fund the school as well. So your community colleges, the U of M, Michigan State, community colleges, intermediate school districts, this public schools, they all get money from that state education fund bucket. Okay, it's $24 billion. Only 2.5 billion of it comes from our property taxes to the state. It's a very small portion. It's less than what Governor Whitmer gave to foreign entities to come into Michigan. It's less than that.
But
What they're talking,
apart from the 2.5 billion
yes,
that goes into the state.
yes.
education,
The
that's
rest of it is
SET tax.
millages.
Right, but there is also, as I read, $7 billion raised in property taxes by counties around the state.
Sure. And so what we're doing, again, is for the townships by request with the ballot proposal, with the summary that Mr. Brader prepared. If you look at that, what we're doing is, like I said, my township already gets more money from general revenue sharing today than what it spends. And we're increasing that amount. We're going to increase that amount. We're also going to make it constitutionally mandatory that every county gets the share of money that it should get. Because like my county, Kent County, they would have received $26 million last year, but that is not being done right now. So we need to do that to make sure if we're removing some of those millages off the property taxes, or if we are removing property taxes altogether, the cities, the townships, and the counties will be getting a redirection of the taxes that we already pay
But
to the
school
state.
districts will not.
The school districts, the millages. So what you're talking about is each individual school district, right? So they have millages. Number one, none of those millages are guaranteed, because we know that in November, there were several of them that got voted down. They got voted down by the people in the community because, number one, they can't afford them anymore. We had one in Rockford. It was for playground equipment.
But $7 billion is currently raised by property taxes, which would not be paid up by your proposal.
But we're not saying that we want to eliminate that altogether. We just want the cities, the townships, and the counties to find a different way. Because eventually, with the way things are going right now, it's going to be impossible for people to keep paying property taxes and afford those services. That's why they're starting to vote no on millages. And if they vote no on enough millages, those schools will lose that money anyway. There was a school in Central Lake. There was a school in Central Lake that had a millage. And it got voted down. That means they will not get that money because the people in the community voted that millage down.
I'm just trying to understand, are you saying that the money that goes to townships and cities would then be distributed by them to the school districts?
No. No, the school districts will have to find another way, another avenue, so they can go to everyone in the community to receive funds
But your
instead of only the
proposal
property
also
taxpayers.
Limits the ability of jurisdictions to create new taxes, does it not?
There are other ways. It's just like when we passed the Headley Amendment and Prop A. Schools were taken off our taxes, but they still survived because they found another way. The same thing with the lottery when we worked with the lottery. The lottery was instigated to remove school taxes off our property taxes, and the schools still they're still there. They haven't, I mean, they always, they always, well, but we're not, but we're not defunding them because the state will, there's, of the $24 billion school aid budget, there's only 2.5 billion of it, or that comes from property taxes to the state. So all of those other taxes are still available to pay for those schools. And we can give the communities a different avenue of funding some of those projects that they need money for.
Does anybody else have questions? Discussion? We have no other public comments on this. Let me start and say that I think until we see an actual petition with all of the altered and abrogated requirements met, that we cannot decide whether a summary prepared by the director of the Bureau of Elections is adequate. So I would not be able to approve any summary at this time.
Just to be clear on the abrogations of the constitutional abrogations that are altered or abrogated. There's a section on the bottom here. My understanding that the attorneys are basically saying that's not a complete list. Mr. Brewer, that was your.
Mr. Housecamp, there is a complete list of the altered provisions, the provisions of the Constitution that they explicitly changed, but there is no list of any abrogated provisions. I gave in my letter just 3 examples. I think there are probably dozens if someone were to go through the Constitution thoroughly and comply with the law. There's no list of abrogated provisions.
With both you and Mr. Liedl here, I'm getting that little pain in the back of my head where I think we argued this last year on proposal 2, didn't we? Where we said, well, there might be some things. It was it?
2 and 3, both last year, both abrogated provisions, and those petitions listed them.
Well, but your response, or one of your responses last year, you've got both of you here. So one of the responses was I think you made the point that it was up to the courts to determine if there were things that were abrogated that.
Ultimately, that's one option. But Mr. Liedl and I and our colleagues who submitted those petitions gave you a complete list of what we regarded as abrogated so you could draft an accurate summary. That's missing here. You have no list at all of abrogated provisions, and so you cannot draft an accurate summary without that. The courts may later on dispute that list, and there may be fights at that point, but you can't prepare an accurate petition without that list. I've never seen a constitutional amendment petition that didn't list abrogated provisions.
Just to make sure you've got a complete answer, I didn't represent proposal 2 of 2022. I represented proposal 3.
I do remember that.
Right.
Yes,
Okay.
I'm
So
sorry.
you may have heard from Mr. Bilcock, but I was here and it certainly was an issue. The opponents of the proposal argued that the board should not approve the proposal as sufficient because it didn't meet the requirement of fully indicating every provision of the Constitution that was abrogated. And it's my recollection that the board deadlocked on that basis. Mr. Bilcock's argument on behalf of 2, I don't recall any challenge to proposal 3 with regard to alter or abrogate. It was proposal 2 relating to elections and voting.
Oh,
issues,
I'm sorry.
right?
Yep. I've got the topic, but the number wrong.
Yes,
Three was
proposal
the
3 in a different year, proposal 2 of 2022. And that was an argument that you heard before this board, that there are provisions that, should have been included in the petition, should have been summarized in the petitions that were abrogated. Some members of the board agreed, others did not. The board deadlocked. Ultimately, the court agreed with Mr. Trebilcock and his client that the proposal included all of the provisions of the Constitution that were abrogated. I think what's different here today is, and Mr. Brewer and I believe agree, is that you have provisions that your director of elections has attempted to summarize that are limited only to those that are affected, altered by the proposal. There's a whole host of other provisions that would be abrogated, rendered ineffective in our Constitution, that would be abrogated, that are not included in the materials that were submitted to you. Including every provision that is abrogated is a mandatory element of a petition for a proposal. So I think Mr. Brewer's proposal position, and I agree, that neither the director can prepare nor can you approve an incomplete summary of a proposal that doesn't fully indicate the provisions that are most certainly abrogated by the language that you have before you.
Madam Chair, may I? Mr. McCord, there's not enough chairs up there for you to come up, but am I correct in assuming, and I think you addressed this, you do not agree with the opponent's interpretation that there are items being abrogated?
Correct.
Thank you. I didn't mean to kick you guys out of your chairs. I want to make sure I had that.
As I have indicated, I believe that we need to see a completely drafted petition before we can approve any summary prepared by the director. So I would not approve the form which he has submitted to us so far.
And I'm of the mind that what's before us is this summary language. And that my understanding of the discussion is there are multiple ways to do this. Mr. McCord and their group has moved forward with the way they believe is best and have not been told they cannot do that by staff. So the issue of the alter, abrogation, all of that is kind of secondary to what's directly before us on this summary. I've heard no argument pushing back, or not a detailed argument pushing back on the summary, aside from obviously what you've said about related to the alter and abrogation. But I can do math pretty easily, and Chair Gurwitz is opposed to moving forward. So I guess we would need a motion here from someone that we.
I believe that because Member Bradshaw is not here today, unless one of the two of you agrees with me, we cannot go forward.
So just in terms of process here, so the statute contemplates that the board will approve or reject the summary. It's not clear based on the discussion whether the board is considering rejecting the summary, or if the board does not feel that, or at least not a quorum of the board does not feel that the summary is properly before it because of the petition language. So the way the board votes on that may determine, should reflect what the quorum of the board is prepared to do. I don't know, Adam or Heather, do you have any thoughts on process?
Let me be a little clearer. I would like to respond to a statement from Member Daunt, and that is, you said you have not heard objections to the summary itself. My position is that we can't approve the summary for the reasons that I said, because I want to see the whole petition. If we were in fact to go forward and consider the summary, I think it is totally inadequate and totally fails to reveal how utterly damaging this proposal is to state and local government finance in the state. So if Mr. McCord chooses in the future to present us with a petition and asks that a summary be prepared, and Director Brader prepares that summary, then we can certainly discuss whether or not it is a summary that we can approve.
So it sounds like your key issue at this point is what Mr. Brader just discussed in terms of whether or not it's even properly before us. Is that correct? Because generally when we do the summary, there's lots of back and forth between the proponents and opponents, and then the three or the four of us. And we often find a way to provide language to the director that can get 3 or 4 votes. So then I believe that the issue is properly before us, but if my fellow board members do not, then obviously I respect that, and whether the vote is unanimous or 2-1 or it will lay out for the proponents. They're not getting what they want today, but it would, in my mind, lay out for them what step they should take next. And so I just want to make sure when we vote on something, we're clear our reasoning so that both proponents and opponents know what it is they need to work on.
So I will move that the board reject the summary prepared by Director Brader for the reason that it is not properly before us, as we have not been given a petition.
Do you want to second that, or do you second?
If you agree with Chair Gerwitz's interpretation, I would second it, because on that issue, I do not.
No, and I don't either. I mean, I would approve the summary. So if you don't have anyone to second.
No, but because there are only 3 of us,
I can still second you, and I can still vote against, correct? That kind of lies in the face of a little bit of a.
Yes.
Theoretically possible. We're not advocating anything, are we? In that case, I'll give you a second for the procedure, but.
And all in favor of the motion to reject the summary? Aye. Opposed?
Aye or no.
Because there are 3 of us here today, we need 1 Democrat and 1 Republican to take action, and so we cannot take action today on this. Well, we have taken action. Right. Yeah.
Staff or legal, are you, for purposes of moving forward, the failure of Chair Gerwitz's motion does what?
Because
is it?
Yeah,
Is it cleaner if I make a motion to approve it
that would more clearly indicate for the record that the board's not acting on either, or is not accepting or rejecting. You tried both.
Can we strike what we just did then and then redo it?
Okay. All right.
Let me pull up a sheet here. Is that okay? Thank you. I move that the Board of State Canvassers approve the summary of the purpose of the constitutional amendment sponsored by Axe My Tax Inc. as drafted by the Director of Elections and presented by the Director on November 27, 2023.
I'll second.
all in favor?
Aye.
Opposed? Nay. Motion fails.
Crystal clear like everything we do here.
So it is 12:25. We have other items on the agenda. I suggest that we take a recess for lunch. And come back on the record, why don't we say at 1:15? 1:30? Okay, so we'll be back at 1:30. Oh.
Do that, yeah. Okay, we just get started. Yeah, okay, we just get started.
Oh, whatever. Yeah,
Whatever is easiest for you guys.
yeah.
We'll just get you.
That was an interesting way to do it. I wasn't sure. I thought procedurally we had to undo what we had just done, but we didn't.
Oh,
Hello? Is there anybody home? Can you hear me, Mike?
We can hear you. We're still in recess.
Oh, okay. Thanks a lot. I wonder what's happening around. Bye. Oh, Jonathan, am I going to be able to speak today or something? There's a little miscommunication on my ADA accommodation. I'm supposed to speak on every item on the agenda, I believe, under the rules. So if we could get doing that, that'd be great. Or if I could get some blue cards. Apparently I need a blue card, right? Still there?
We've got your request and the chair has it.
Yeah, yeah. Okay. Thanks a lot. And did you get my issue on the agenda? The chair at the last meeting said my issue that I submitted was going to be on agenda, that special meeting and whatnot. Is that on the agenda today?
Chair addressed it, but you have comment later on, so we can talk about it then.
There's just a little bit of common law in America that you folks don't seem to be catching. And you one rule at one question at a time, and your statements need to be germane to. You just didn't do it today either. You just did it with the people that were these things you just approved. There's only 3 commissioners. Article 2, Section.
Whoops.
Looks like it's recording and we're on. Yeah, I don't know. Said, yeah, said faintly can hear. Think we might be good now. If Mr. Gallant is on.
Mr. Gallant?
Yes, can you hear me?
Good afternoon.
Okay, am I on then? I guess. Okay. James Gallant, Marquette County Suicide Prevention Coalition. These are my opinions. Madam Chair, I would hope that you would honor your decision at the last meeting and address my request to get a special meeting with a public hearing to consider the Secretary of State and the Attorney General of Michigan's opinions on Robert's Rules of Order being required under the Constitution of Michigan. The Michigan Independent Citizens Redistricting Commission was instructed that they must follow Robert's Rules of Order. They were also instructed they must follow the Open Meetings Act. And Robert's Rules represents common law in America because it's a direct interpretation as much as possible of the House of Representatives. And in all societies on earth, common law is determined by the legislature of that country. So please get that special meeting. And what you just did today, these decisions you made today violates page 3666, line 8. There shall be no debate before there's a motion for proper second. And also, Article 2, Section 7 of the Constitution says there shall be no majority of either party on any canvassing board. And you are clearly making decisions with a majority of Republicans on the canvassing board today. So I would think that these people that got their petitions rejected, they should take this to court right now, saying that you followed common law in America. It's like you don't want to follow Robert's rules, but you think any number of those rules, you can just say that's common law. You just get to do it. I mean, what is your rule on making a motion to reconsider, motion to amend? Where's the motion? Where's the rule at? It's in Robert's Rules of Order book. See, but this is communism. It's Marxist style communism to start with the discussion first. You decide the question and then you make the motion. That's Marxist style communism.
Mr. Gallant, let me interrupt you. We had a quorum this morning and we have a quorum now. So we were able to.
You didn't when you just did those two petitions.
And Mr. Gallant, you sent us about 250 pages of information regarding your position, which I did look at.
That was an article from Wikipedia.
Mr. Gallant, let me talk.
That's citation. Okay? Please put it on the agenda, please.
Mr. Gallant, we are not going to ask the Attorney General for an opinion on whether or not we have to follow rules.
Is Dana Nessel there?
Mr. Gallant, just listen to me. There is a long-standing Attorney General opinion saying that state boards are not required to follow Robert's rules.
It doesn't say that. It says not necessarily. It says not necessarily. That means it might be. It says not necessarily in that opinion. It's in the Open Meetings Act manual.
We have interpreted it, and our
you haven't got Dana Nessel. We need Dana Nessel.
Exceeded your time.
Dana Nessel. We need the Attorney General.
Cut him off. The next item on our agenda is to consider proposed legislative changes to the law regarding initiative and referendum petitions. So people will recall that when these were initially proposed to us last spring, we had questions about whether our role under the statute was explicitly defined. And so we convened a working group. Member Hauskamp and I were part of that group, along with many practitioners who had opinions about whether statutory changes were needed, and also just about procedural changes, which would make their work and perhaps our work better and more efficient. So the Bureau has distributed to the practitioners the information which we have here, proposed changes so that the deletions are struck and the additions are in red and underlined. So what we have basically done and what we propose to recommend to the legislature are changes which would explicitly recognize that we will use statistical sampling to evaluate the validity of and sufficiency of petitions, both for initiative petitions and for candidate petitions. So with regard to initiative petitions, that's a recognition of what has long been the procedure followed. With regard to candidate petitions, that is a new procedure. And what became evident to us with regard to what was happening, excuse me, with candidate petitions was that the Bureau had time only to do a pretty, not sketchy, but to do a curse, that's a good word, better than sketchy, a cursory review of the petitions to see whether they appeared to be in compliance with the form requirements. But that did not include any significant review of the validity of the signatures. So that if there were challenges to the signatures, then those would be addressed by the Bureau. But the Bureau would not independently have been checking the signatures against the qualified voter file. If I say something that's inaccurate, gentlemen, you are gonna tell me. So if we use random sampling for the candidate petitions, it will result in a much more substantive review of the validity of the signatures. We would draw, I believe, is it 750 signatures? And that would allow an examination both as to the validity of the signatures and the compliance with the requirements of the statute with regard to petition form. So the acknowledgement of statistical sampling for initiative petitions and the expansion of that to candidate petitions is something that we're asking the legislature to incorporate into the statute. Although I will add, we don't think that it is essential because we've already decided to do it, but we do think that it is important for the statutory authority to be explicitly recognized rather than just the general grant of authority that we have had up to date. One change that we have made, and I'm sure you're going to have some thoughts about this, Member Daunt, is that you will see on the first page under section 476 that we are recommending the word substantially complies. I think there was general agreement. I know there was general agreement among the practitioners that would be an improvement, that we wouldn't have the kind of gotcha examination of petitions, but really look at them for substantive compliance. The strict compliance requirement was only judicially enforced in Stand Up for Democracy in 2012. Substantial compliance had been the practice for decades prior to that. But it has, since Stand Up for Democracy, the strict compliance has resulted, in the opinion of the board, and I think of the Bureau, and I think of some board members, has resulted in some really harsh decisions and rejections of petitions for fairly small and insignificant compliance. So we don't know what the legislature will do with this, but ultimately it's their decision. So what we're talking about here is making recommendations to the legislature. They may be looking at other changes in the petition process. I'm sure they will. I don't think what we're going to do is ask the Bureau to deal with the legislature. At least that's what is being suggested here. But obviously, the legislature will be taking a look both at what we're asking them to consider and also at what changes they think might be in order. There was discussion, although it's not incorporated here, about having filing fees rather than nominating petition. And that's probably, it would make our job a lot easier. It would make the Bureau's job a lot easier. And that at least for some positions. However, I think that we concluded that that was not a decision for us to make, but for the legislature to make. I think that pretty much covers. I know that we have some fairly minor changes in here that just really confirm, or that may just be style changes, or that confirm things that have previously been determined. So I see that Adam has in here that the petition has to specify residence address and not just address, based upon litigation that I had with them a couple of years ago. So we're clarifying things that were not previously clear. I believe that about covers it. So the substantial compliance standard is incorporated both in 476 and in 482. That the petition must be substantially prepared in the following form. So we would not reject petitions that have a couple of words cut off if it's not a material omission. Oh, right. You know, I think they would have done that anyway and did do that. So it does, right. Well, actually, this makes it mandatory. So we're using the word must here. I don't know if we get reports on what happened. You know, with regard to the forgers.
I don't have any more information other than what has been publicly discussed. Yeah.
There are some provisions that are both in this and in other parts of the election law that are simply not up to date in terms of the kind of notice that is given, or what kind of notice is required. You know, for example, in 480 about furnishing copies. Everything can be done electronically now. So some of the previous requirements are no longer necessary. This eliminates, because it's confusing, this eliminates some provisions which were held to be unconstitutional, but were still in the statute, had not yet been struck. So, and that is particularly section that is, but those are the provisions from PA 608, which required circulation in the congressional district. Okay, so it is. In part, section 482. So that is it. Those are the suggestions that we intend to make if the board is in agreement. And there have been significant discussions about procedure. We had those discussions when we adopted the revised petition manual. And those are, I believe, continuing. Oh, there is in section 471, I should note, on the first page, there are changes in the time. So the recommended change is to have petitions submitted at least 160 days before the election as opposed to 120. And Article 9, that's for Article 12, Section 2. And Article 9, Section 2, amendments to the Constitution 200 days before the law, before the election at which the law would appear on the ballot. So that's just giving the Bureau more time. And people who are objecting also would have more time to raise their objections, and we would have more time to address them. Anything else? What have I left off?
I think that you've covered it pretty well. Nothing, the only other thing I would add is just as I was going through and opening some of the sections to make these changes, I cut or tried to clarify provisions that courts essentially have told us over the years. So for example, in 471, we have the Michigan Supreme Court has ruled the 15% minimum on signature requirements is unconstitutional. So we just struck that provision out. So these decisions where we have court opinions on, I've tried to just, where if they've been declared unconstitutional, to remove them from the law and make clear exactly what the requirements are in across the entire chapter. So I'm happy to answer any questions if you've got specifics.
So one of the peculiar things, like as with regard to section 471, is that even when the Supreme Court has said that provisions are unconstitutional, they're still there in the statute, and there's a footnote essentially that says that this has been found to be unconstitutional. And that's hard for people who are looking to discern exactly what the statute says. I think at some point, and I'm not sure exactly when, the Legislative Service Bureau may make the change, but in the absence of a change having been made, we're suggesting it here. I think that this does what we wanted it to do, which is to clarify what our obligation is, and that is to determine, and it's in section 476, to use statistical sampling to determine the validity and sufficiency of signatures and petition form requirements. I don't think that we had recognized our responsibility to ensure that the petitions were compliant, but that was not specifically stated either. So it is now. It was stated in some other provisions, but this incorporates it into a general statement about what the Board of Canvassers' obligation is.
From a timing perspective, do we need a motion of support from the board today to forward this to the legislature? Is this something we have a bit more time for digestion with? I'm assuming that we would have a little more time for digestion. Frankly, I didn't spend much time looking at this or as much as I did looking at the other items that we had before us today, because those I knew needed some decision. And I asked, just because there's, I see some comments, right? I'm aware of some comments from like Chris Thomas on some of these things, and obviously well-respected mind in this field, and digesting some of those would probably be helpful for, at least for myself. And so I just want to know, do you need something from us today, or?
So, I mean, we'll forward it as soon as the board, if and when the board wants us to forward it. So there's not a specific deadline.
I doubt if the legislature would be acting upon it before we have another meeting. Do you think?
Unlike, yeah, both dates are to be determined in terms of our next meeting in the legislature, but I mean, likely not. They would not do anything with it right away.
Give the legislature a deadline. Obviously, the legislature has had a lot to do and has been busy, and this has not been, we did not consider this to be a priority in terms of getting this to them. So I expect that they will have time to address it next year. If they choose to do so. So.
Yeah, probably just from so I am fully digested.
Yeah,
I know you two have spent a lot of time in the practitioners, and I think this is great. I just want to make sure I'm fully digesting any changes in what some of the unforeseen consequences may be.
We're putting a piece in here. We're putting a piece in about substantial compliance as a full face review. Have we defined what we mean by substantial in any kind of should we be putting a definition of that in here?
I'm not really sure whether there was board practice or case law defining substantial compliance prior to Stand Up for Democracy. I don't know how developed that is.
Thinking ahead, we could save Mr. Brewer and Mr. Lynch a lot of writing time here.
I'm not sure you could, because I think whatever definition you come up with could still be subject to discussion. I had thought of something like incorporating the concept of materiality into compliance. That there would be, although it's hard to define, and substantial compliance was a concept that was enforced and followed by the Bureau prior to the strict compliance determination of the Supreme Court. So I think that using the term substantial gets us back to where we were prior to Stand Up for Democracy. You think, Heather, do you think that? I mean, it's essentially rejecting a decision, which the legislature can certainly do, rejecting an interpretation. But the Supreme Court's interpretation was based upon language that said must. And if that language is removed, then substantial compliance more naturally follows from. So I don't know. As I said, I think the concept of materiality would possibly be incorporated, but it might be something that you're better off not defining. However, I talked to Chris Thomas about this, and he said substantial compliance was never a big issue for them. in terms of never a big issue for either the Bureau or the board. That it arose infrequently. The questions did. And so, I mean, this was certainly a change from his perspective that was in order. Jonathan?
Yes, well, I only know the world of strict compliance, so I can't, I'm not gonna I mean, obviously that, we would then make recommendations to the board based on our assessment of whether something was substantially compliant. So I think, of course, there would be disagreements on individual petitions that would likely track how, those coming before the board felt about the merits of those petitions or the names of the people on them. But I mean, I don't think it would be a major problem for staff to consistently apply a substantial compliance standard. Obviously, it would lead to those, those decisions then having to be made by the board. The easier thing about strict compliance from a staff perspective is it, although it's not always, even with strict compliance, 100% clear what the right answer is. It's an easier, sort of simpler, more objective standard to apply. But I think we can make recommendations to the board on a consistent basis under either standard.
Thinking too, though, of the people who appear before this board, someone who's gone out and invested a lot of time and money in doing a campaign. By us taking away full face review and strict compliance, putting in the term substantial, are we setting people up for somebody who comes before this board with 200,000 signatures and if we reject it based on something on that form that wasn't filled out properly, and they say, well, that wasn't substantial. Would it help if there was even an attempt to provide a couple of examples for instances, footnotes of that document? I mean, there's some things that are obviously substantial, right?
I think, well, I'll defer to Heather on the legal question, but I think in terms of practice, I mean, we could certainly over time provide examples of determinations that the board made as to, this was substantial compliance and this was not substantial compliance. We've done that with, for example, the recall petition wording. We've built the document of the sort of the history of the board's decisions on those so that you all can look at that as a reference, and also those who are drafting recall petition language can look at that. So we could certainly, over the years, if this were to become the law, we could build that document so that there's a little more common understanding of what does or doesn't make the cut. But Heather, did you have something you were going to add?
No, I would just say, I mean, if we go back to substantial compliance, I think that we could still rely on the cases from when it was substantial compliance. They may not be, binding in as case law anymore, given stand-up, because stand-up would still be, the case, but they would still be examples of what courts previously found to be substantially compliant. So they can be sort of added to a list of examples of what courts, found when substantial compliance was applicable, what prior courts found to be compliant or didn't, what failed. So there's not heaps of cases like that, but there are a fair number. I mean, you can find those and annotate those. There would be some examples already that we could use.
And certainly in the petition manual, there could be, that would incorporate the kind of guidance that practitioners need. Because it's clear that they do look to the manuals. They do, sometimes more than others. And the manuals don't always answer the questions that people have. But I think that we could provide the kind of guidance. But what we've done in determining that something is non-compliant was quite often a difficult and somewhat painful decision to make. If somebody copied a petition and didn't get all of the words on it, that was not material, really. but it was something where we felt that we had to say that it was not substantially compliant. And so this would not require us to make those decisions, which seemed to us essentially unfair, but necessary. So.
Give us a little more room.
Yeah. Yeah.
And it would give you folks a lot more room to do. A lot of this stuff is gonna. Yeah.
In my mind,
Because it's still gonna be a recommendation ultimately from us to you, and of course, anyone who disagrees with that can come before the board and bring those arguments directly to you. So yeah, I mean, certainly, you know, we don't enjoy recommending that someone not make the ballot because of a copying error. So from that sense, you know, it would be, you know, it would allow us to avoid those types of seemingly harsh outcomes, you know, and we'd just be trading that for, you know, more disagreement potentially about whether something was substantially compliant.
that's the thing that concerns me, at least initially, of making a change is just adding additional avenues for a difference in interpretation. Just the nature of this board and just the world we live in is there, you know, people will have differences of opinion and interpretation that can't help but be colored by, you know, other items. And so are we opening up for even more deadlock on certain things like that? Like there's a gentleman I recall from last year. He was running, I think, for Congress, and he had the appropriate number of signatures, but there was I don't, neither one of you were on the board at the time.
It was the state senate. He was from Detroit. It was the pastor who had.
And there was one of the mandatory elements was slightly covered because of a whiteout or something like that. And we had to reject it because it was required. And it sucked to have to do that to him, but at least the law was clear. You have to have this, you know, sorry that it, and so I just have concerns that we're going to have even more of that if we move away from strict compliance, and maybe there's a way to do it where certain items must be strict, and then there's some other where substantial is okay. It's just kind of my initial thinking on that.
Well, a thought on that same thing is, I'm assuming that this is going to save you folks time in the process. That was where it all started, the saving time on face reviews. But I would also assume that as you prep your team to go through and do reviews, partial face reviews, substantial compliance face reviews, Director Brader, I would assume that you would take your team and put them down and say, okay, here's a couple of sample petition sheets. We have highlighted in yellow or whatever your venue is, what we're going to verify. So there would be some track record here of what.
Well, so I think, you know, certainly doing the review to ensure compliance with form of the sample as opposed to the whole universe, that will give us more time with each sheet. So we can take a much closer look at each sheet because we're instead of scrutinizing in detail, you know, tens of thousands, it'll be about 1,000. So that will save us time. What would take more time under this, and that's going to happen either way, I should say, strict or substantial. What will take more time under this, under sort of a substantial compliance regime, is we would first still be looking at, does it comply strictly, right? I mean, because we'd be identifying any difference between what's on the petition and what's in the statute. Then once we identified that difference, what we'd have to do under this is say, okay, notwithstanding the fact that it is not strictly what is in the statute, does it substantially comply? So that in that sense, it would take longer for those types of petitions where there was not strict compliance. Again, I think over time, once we've built up, working, at the staff level and then seeing how the board's handling those decisions, I think we would have a pretty clear precedent to work through those. But I could see in the first couple cycles, that adding some time when we tried to come up, with a consistent approach as to what constitutes substantial compliance. Yeah, so that's, it would be, the substantial aspect of it would add some time, but I think we could manage either way.
I would remind us that even when we have been adhering to a strict compliance standard, we have arguments about whether there's strict compliance, right? Right, so the union bug was the most obvious of those, but that had to go to the Supreme Court, right? So it's strict and substantial are not necessarily binary, right? And we see some good attorneys who make creative arguments. And there was agreement among the practitioners. No, actually not necessarily. There were a couple who thought that strict should be adhered to, but I think the general opinion was that it does not advance the interests of the public or of board. So I would just, let me just illustrate with a case that I had. Where a judicial candidate for circuit court position went to his clerk's office to get the petitions, he had them all filled out. And the Bureau recommended rejecting his petitions because they had changed the form. And the clerk didn't know that they had changed the form, and she gave him the old forms. And he had not done anything but attempt to comply. And I did persuade the board because it was just too awful to keep him off. So they said he substantially complied, even though it was the compliance standard. It was, but that's the kind of position that the Bureau and the board had gotten into by being overly strict about strict. So
that's a good case. That's a good.
I notice in here, there's reference to things at the local level of county or city clerks and what they may, can, shall, must do with some of these items. Has there been, there weren't no people in that practitioner world part of these discussions, correct? Am I correct in that? Have any of them, whether it's, a county clerk like Barb Byram or Lisa Lyons or, city municipal clerks, have they expressed any thoughts or concerns related to these things? Or is this just meant to kind of make the local process match up with the state process?
So in clerk meetings over the last year and a half or so, I've talked to some of the clerk associations about this project, and we have not gotten like a formal position or anything from the clerks. I imagine if there were legislation, there's a good chance that the clerks associations or perhaps individual clerks would weigh in at that point. I don't know if I don't want to attempt to speak for any individual clerks or the majority of the clerks in terms of the strict or substantial issue. What I will say is I think it's overwhelmingly the case when we talk to clerks about this that they want a clear, consistent standard that they can apply. So obviously, to the extent it's in the election law, that would provide a greater amount of clarity than what we can do, and sort of telling them, well, if we were reviewing this, what we would recommend is X.
One of the really useful things, I think, that happens in the legislative process is that you have these the Association of Municipal Clerks and the Association of County Clerks, which have significant impact and input. They have their concerns and they want to make sure that the legislature understands their concerns. And I know that this past year, one of the things they've been addressing is time, you know, and how everything is getting compressed and they simply don't have the time and resources to do what they are being directed to do. I don't think that the issues that we're raising here, which primarily dealt with what we're doing, I don't think that that's their issues too much, but whatever we recommend, they're going to have. They participate very actively at the legislative.
And I recall I think it was in a dissent from Justice Zara last year, he raised kind of similar concerns about timing and that, you know, that it's so compressed that they get these important items before them, but their hand is often forced to just, I want to say go along with the status quo, but you know, because of the timing, they're forced to kind of make a quicker decision than I think they're want to do.
Right, and I think that what he has said is that they have not had the time to get full briefing and oral argument. And I'm not sure, you know, elections are getting more complicated rather than less, and the ability to provide Justice Zara or any other justice with more time to decide some of these issues that only come up at the last minute. I don't know how we could do that, but that's another, it's another thing to consider because the time is so complicated, both with regard to the 45 days military absence and now the early voting. The pressure that has been put on clerks is really significant. And probably, and this is not our job at all, but moving the August primary would make huge difference to them. I mean, it's not necessarily something that it's something that has to be done, as I understand it, with a lot of lead time. But it is something that I know that the folks.
I think in a past life past position, I dealt with that issue of the primary and, or at least at the time personally, was supportive of that for some of those reasons. And I actually think a Republican may have sponsored the legislation doing that at the time.
So I don't know if there's much of a
yeah, and I did not to mean I didn't mean that to mean that because it was a Republican it was good. It's more that it's kind of a bipartisan issue.
Right. So I think we could think about this a little more and read it a little more. It'd be fine.
Did you add this to the agenda for January? That would provide
Yes.
enough time.
Yes.
Unless you want to call it
Right,
I'm
but
done.
I too would like to look at Chris Thomas's comments because I find them always helpful.
There's another piece of this though, too, right? There's a second. Director Brader, you sent out a letter dated today, which I think also that's more on the sampling procedure.
That's right, yeah. Yeah, I was gonna raise that at the board's preference, of course, during other business, but it's related. So we can talk about it whenever the board would like to.
Do we want to highlight that one while we're here today?
Yeah, I'm certainly happy to do that. Yeah, so at the October 20th meeting, when the board approved the sampling procedure, correct? So at that time, the board approved the sampling procedure, but Mr. Doster was present at the time, noted that there were other aspects of how we process petitions at a staff level that are not part of the actual formal process of reviewing signatures and making determinations and then recommending them to the board, but rather just about how we handle the process and how we make information available to the public. So we agreed to take a look at that and see if we could put more in writing to basically just make that clear for everybody involved in the process. So we looked at the letter again and just sort of looked at our own procedures and practices. And so we've added to our sampling procedure document that we've posted information about how members of the public, whether they be sponsors or challengers to petitions, or just members of the public that want to see what's going on and provide input, can get that. And so we've added all that, including the fact that the list of sheets and signatures sampled will be posted. That'll include the total number of signatures and sheets in the universe, and then also the staff report that includes the statistical analysis. We also make clear that we will scan and make available through FOIA all the sheets, both in the entire submission and in the sample, and that there are ways, if people want to come and do their own inspection, they can do that. That will require waiting till our scan is done, and it will require an additional fee just because of the time and cost of that process. We also made clear in writing that the final report that we generate will include the statistical report that comes out from the module that we use to determine whether they've met the signature threshold. We also include some more information about how we will facilitate communication both with the sponsors and the challengers of petitions, including quick responses, including making sure that challengers and petition sponsors and challengers are copying each other on their communications, or if not, that we're forwarding those. So that is all laid out there in our opinion now. I think for the most part, it does track what the practitioners were requesting. And frankly, most of what we've already done. There's a couple things that we're not able to accommodate right now. So one is, we talked about it at that meeting, was just the members of the public being able to see the digital driver's license signatures on qualified voter file. We just can't, in our opinion, provide that under the election law. Similarly, this isn't really a statutory issue, but just a practical issue. We don't have signatures from out of state circulators, so we can't review those to see if it's their signature. And then the other one, sort of the main one, was just requests for more sort of periodic interstitial information about where our review was. So we've gotten requests basically to get like a daily rundown of the signatures that may be invalid pending review. I can completely understand why that would be helpful for the practitioners, but it's just not practical for us to kind of stop our review process every day and then produce a new report. We really need time to have that internal review before we put it out. So that's not something that we, at this time, think that we can accommodate. Although, as noted in the process, we are planning on recommending to the board, after we've gone through the first review, or as we're going through the first review under this new process, providing an extended period, more time, both for challengers and for sponsors to look at the signatures and make their challenges and their rebuttals. And that could potentially include also more back and forth. So that was one of the main goals, frankly, of this new process. So I do think we'll be able to provide more information during the process, but just not exactly in the form that, at least Mr. Doster is asking for. So the updated sampling procedure document we put out reflects that. And that was the update essentially that we promised at the past discussion. Oh, and Mr. Doster did also email a response that you have a copy of. Thank you.
Right. And that was sending his prior communication.
Yeah, and I think reiterating the interest in getting more
Right.
sort of daily information.
Right. Are we on to other business? Do we have any other business? I know that we have agreed that we have other business at 4:00.
Right.
But we've got an hour. What do you want to talk about, guys?
Well, so I guess just to close out, some of the prior discussion on the Axe My Tax petition, because I assume it's coming back in one form or another. And I know we didn't talk about the substance of the petition. There's a little, or the summary of the petition. There was some discussion about whether the summary should include some of the effects of the petition that aren't necessarily expressly in the statutory changes. That's not unlike previous discussions that the boards had on 100-word summaries. In general, obviously, there's an argument that sometimes when you're talking about the purpose of a petition, that should include the material effects of it, even if they're not literally, in black and white on the petition, but sort of the secondary or indirect effects. And sometimes I've drafted summaries and the board has approved summaries that go more in that direction. I don't think there's necessarily a hard and fast rule about when those types of additional effects need to be in there. I think that the challenge in doing that, in providing additional information about what would happen if this petition were, or if this initiated law or constitutional amendment were passed, the challenge in doing that is maintaining what the board agrees is a true and impartial summary, and then also staying within the 100-word summary and doing all of that. So, but having heard that, there were concerns with this summary as drafted, I'll certainly take a look at that, take a look at any other materials we give. I will also note that we always do provide a period of time for individuals or organizations to tell us what they think the summary should be before I draft it. So obviously we'll look at anything that gets submitted then. But ultimately we will need to have a summary that I draft that a majority of the board agrees with. But I will definitely keep that discussion in mind as I'm drafting whatever comes in the future.
So when I looked at, again, at section 482B, it said it's the summary of the purpose. And I think the purpose may be something that is larger than just a summary of the content. And the word content was also used in the statute because you are supposed to summarize the purpose, and then the board of state canvassers determines whether your summary of the content, let me find that again. Summary of the purpose proposed is prepared by the director of elections. Board of canvassers approves the summary, but there was, oh gosh, I'm not finding a section where it said that we look at whether we approve your summary of the content, which is supposed to be a summary of the purpose. I'm kind of, oh, here it is. It goes to the board of canvassers for approval as to the content of the summary, but the summary has to state the purpose. And so I think it's possible that those are two different things, and that just doing some rather mechanistic summary of the terms of the proposal really does not convey the overall purpose.
No, your point is well taken.
That content and purpose are not necessarily
They're not
the same
necessarily
thing.
the same, but that also leads to the fact that some of these petitions, as we've seen, particularly the one this morning, the purpose may not be crystal clear. There was a lot more about simply changing the Constitution than there was about why. I know I'm coming from the point of view of looking at summary that the grader has very well structured, a little bit on the Hemingway side, being able to keep it down to 100 words.
Pardon me, the interpreter is struggling to hear right now.
Sorry, if the board members could try to be closer to their mics while they're speaking.
Oh, there we go. Sorry about that. Chairman Gurwitz, your point in that summary should have shown more about what the impact would be. Looking at what you were looking at what you were talking about for the impact, that would be a lot more than 100 words.
It's right. And with a proposal of such magnitude, 100 words is really a challenge, whether it be for Director Brader or for Hemingway. It's
So then,
it's really, really hard. And therefore, whether instead of talking about or summarizing the individual nitpicky parts, there would be something broader and more generic. And I don't know if we want to discuss what it would be in this context, but one of the things that I think we have said in the past when we're trying to think about these summaries, what does the public need to know if they're being asked to sign a petition? And I believe we have all articulated that that's something that we're thinking about. What do they need to be told?
and you're touching on a larger issue. I mean, there's an alarming sense here of very, very significant issues like constitutional amendments that we are asking voters to decide somewhere in the rain between their car and the front door of the supermarket and just go ahead and sign. I mean, that's the problem of the tables out in front of public places, right? There's not any research going into it, whether you have a longer summary or a shorter summary.
Right.
You
know, and there's always the problem of whether with regard to the tables out front, one of the things that you've suggested, and I think you're correct, is that often there are no circulators there.
Right.
There's just a bunch of petitions. But to the extent that that's the case, just the language, the 100-word summary becomes even more important if there's no circulator.
word though, again, back to brevity though.
Right.
Um,
So what is the purpose of the statement of purpose? Is it to convey in as accurate? Well, we're told what you're supposed to be doing and what we're supposed to be reviewing, but overall, it is to inform the person whose signature is being sought what this is about. So if it's about a major change in the funding of government, should that be the lead? And I could certainly draft my own, and it would, I'm not sure it would necessarily be an impartial statement of the purpose, which is what you are required to do. And I recognize that statement of impartiality, which does not create prejudice for or against, that's really complicated. And the task is a hard one, but if we think about it from the perspective of the person who's being asked to sign, what do they need to know?
Mm-hmm. Yep. That's a very good way to put it. In a perfect world, what would be fun to do would be to require them to put a QR code on the front and give people the ability to go look at a lot more research, but that doesn't work with the process. I don't know that.
It probably also doesn't work with the public.
No.
It would be nice to have public who wanted to do that research, but
they won't do it.
No.
I don't know that I don't know how Director Brader could have written that particular summary any differently and still had it make any kind of sense. You caught the fact that by eliminating property tax, also involved was restrictions on raising income tax, and also involved were mandates on how money would be circulated. That was the purpose of their proposal, correct?
Well, I think, yeah, I mean, again, it depends on the definition of purpose. Obviously, I think it could be interpreted narrowly in terms of what is this doing? You know, what is this doing to the Michigan Constitution? Or, you know, more broadly, like what's the policy purpose? And I think, I don't know that either one of those is 100% the right way to interpret purpose. I think what I try to do is capture the most important legal changes that this will make. And what is often the biggest sticking point with the board, but one that we've always been able to agree on ultimately after each meeting, is just getting enough of that core summary of the provisions in there in a true and impartial way, and leaving out what you can leave out, understanding you can't always put a summary of every single thing in the proposal in there, to make enough room to explain what the overall impact is, but also doing that in a way that is true and impartial. So I think this is helpful feedback for me in understanding the board's thinking on that. And I, you know, necessarily it will require probably scaling back a little bit more explanation of all the provisions in there to allow for that, but I'll keep that in mind. And then ultimately I'm optimistic that after some discussion, we'll be able to agree on a summary, because that's always been possible in the past.
Am I correct in assuming, though, if we had taken the next step this morning, if we were having this conversation right now with the petitioner here, one of the actions we as a board could have taken would have been to have kind of weasel worded or wordsmithed that summary to something that Chairman Gurowitz and
Right. I mean, I think typically in the past, it's been a round of discussion. We've considered different phrasings as options. And then once everyone agrees, I'll then type another one out. We'll print it out. We have a printer here. And then that ultimately we've always been able to do that in a way that's gotten enough votes. So I think we'll be able to do that again with this one.
You did make a mistake. I don't want to be too picky because I don't like any of it, but yeah. Yeah, I just think whether we're talking about purpose, or impact, or underlying policy, that what do they need to know? That makes sense. I don't know.
This has always been, it's always been a delicate balance, because obviously the proponents have an interpretation vastly different from the opponents, supporters and opponents. And since I've been on the board, I think as a group, we've always done a good job of having back and forth and trying to find a way that, you know, in working with each side through that process, we can come up with something where, you know, both sides get a little bit of what they want. We agree to it, and Director Brader then writes something that can get at least 3 votes from us. And it is difficult, but I think it's been done quite well by this board in the time I've been on it. And then thinking back to other instances where I came before the board or was part of a group that came before the board, I think they did it well. So
It's particularly difficult with proposal of this complexity. So maybe we want to change the statute to take 200. I'm joking about that, but you know, it is really hard because this would have enormous impact on our state, and to convey that is important. It's, you know, so if you just say, oh, get rid of property tax, oh, I'm sorry to pay. house foreclosed or my neighbor's house foreclosed. But then you have to the next and the next and the next step. Oh, but okay, the next steps, right? So we'll see if you have the opportunity again. I expect you will.
The place for the extended summary and what you're describing and listening to you is beyond the province of this board. It's in the media and it's in the discussions in the
is.
homes. And it's in anyone who would walk from the car to the library door in the rain and make a decision, seeing that for the first time.
About whether they want their library to be funded.
Well, sure, but I'm saying that anyone that would walk up to that proposal cold and provide a signature, I don't think 200 words or 400 words or 1,000 words is going to change that.
I think you're correct. Yeah. I do note for purpose of this, just an observation. I don't think that this would provide funding for the conduct of elections. It is not defined as an essential service.
Yeah, so I mean, that would be the type of level of detail that, the balance is. Do you use the term, essential government infrastructure services, or do you try to explain what that is? And do you have the words to do that? So, I mean, it's certainly, I would imagine that would be a question that people would raise when we're getting into the substantive discussion of what should be in the summary.
So this is a fruitful discussion, I hope.
Yes.
And
I have-
it's good to have.
I have one request or suggestion totally unrelated to what we just talked about. If there's a way to make it not a sauna in here for when we come back at 4. I run hot though, so maybe I'm a wrong person to make that request, but I feel like my head's gonna fall over right now.
We will try.
Or is that what you?
We'll have some more time for doing our raise the wage brief because got an extension from Mr. Brewer. So once we get that drafted, I'll circulate it for you guys to take a look at.
And we are waiting for people to file by 4 o'clock to run in the special election in the 13th State House District. And when they do so, we will certify. So we will recess until 4 o'clock. 4:15. Maybe we're gonna have a card game or who knows? We should. My husband and I used to go to this incredibly slow restaurant, Indian restaurant, and we took a portable chess set.
Oh, yeah.
Play during course. You want us to read the names?
You should read it. Oh, so, okay. We just want to just say us, attach it. Okay. Well, I could just make. Whatever.
Okay, on the record at 4:20. To certify the candidates for the 13th district representative in the state legislature, partial term ending 1/1/2025. Member Hauskamp, do you have a motion?
I move that the Board of State canvassers. I move that the Board of State canvassers certify the candidates appearing on the attached list as sufficient and the candidates be certified to the Secretary of State for the January 30th, 2024 special primary election.
We have a second.
Support.
All in favor?
Aye.
The motion carries. Do we have any further business? Meeting is adjourned.
Thanks for saving us a trip on Friday.
Thank you very much for sticking around. Definitely.
So Suzanne and Curtis, different parties. There are these lemons. We've been
Yeah.
running the things in Detroit and winning things.